May it please, my lord.
Yes.
My lord, prayer for upgradation of item 48, my lord, of the supplementary list. My lord, pursuant to the last order, it was stated that it will be taken up for final consideration. If it pleases, my lord, then it may be taken up at 2 o'clock, my lord.
Pardon?
My lord, it may be taken up at 2 o'clock.
Okay.
Item 48.
Okay.
I'm deeply obliged. My lord, one moment. My lord, item 44, my lord. I am for the newly implemented respondents 5 to 17. My lord, I'll file my Vakalatnama and my lord, the affidavit in opposition shortly. My lord,
Item number 44.
44. I have taken consent of the other side. My lord, it may be adjourned for today, my lord.
Item 44.
Interim should continue.
44.
Interim should continue. I am for a petition on which.
Your name?
Arguhan.
R?
Arguhan.
What is your name?
On behalf of Korea.
So I'm appearing on behalf of my senior
Who is your senior?
MK Sudhir.
Mr.
TR Sarma.
P.R. Sarma,
For
learned
respondents 5 to 17.
counsel. For respondent number 5 to 7.
17, my lord.
17 submits that he will be filing his power today. Then he prays for listening the matter.
After, my lord, 3 weeks?
2 weeks.
2 weeks.
After
2 weeks. Deeply obliged. My lord, my name is not reflected there because as per the IA, my lord, last order passed by this honorable court in this case, there was an IA, my lord, for impleadment. Impleadment was allowed. 7001.
interim order passed earlier shall continue.
My lord, my name may also be reflected. My lord, we'll file couple. Deeply obliged.
May it please your lordship, my lord, with regard to item number 13, my lord, I am from the respondent Borderland University, my lord. I have taken consent from the petitioner, my lord. It may come after 2 weeks, my lord.
Mr.
VK Borua, my lord.
V.K. Barua,
Lordship.
learned counsel appearing on behalf of
Respondent Borderland University, my lord.
respondent in Boduland University, prays for listening the matter after
2 weeks, my lord.
2 weeks. You inform the other side.
I have taken consent, my
With
lord. I
consent
have
of the other
already
side,
submitted
prays
the
for listening
application, my lord.
after 2 weeks. Fair lord.
High level.
May it please your lordship, I beg to mention item number 36, lordship. Kindly matter may be withdraw, lordship. Petitioner got relief, lordship.
Item number 36.
36.
Ms. Zay Ghosh, learned
Yeah.
counsel. For the petitioner submits that this WPC become infructuous as the relief claim for has already been granted by the respondent authorities. Accordingly, taking note of the submission of Ms. Zagos, learned counsel for the petitioner, the read petition stands closed.
Oblige, lordship.
Okay, Mr. Sharma for limited.
May please, Lordship.
Yes,
I beg to mention item number 5, Lordship.
5.
For respondent studying our higher education, Lordship, I have consent.
My lord, I'm for the petition amendment.
List of
Okay.
2 weeks, Lordship.
Mr. Punya,
Lordship.
learned standing counsel
Higher
for the
education.
higher education department with consent from the other side, place for listening the matter after
2 weeks, Lordship.
2 weeks.
Read,
Fair
my
lord.
lord.
Lordship, item number 11, under instruction of my client, I want to withdraw the petition. 11.
11.
11.
Mr. N. Islam, learned counsel for the petitioner, submits that he has the instruction to withdraw this petition. Liberty?
No,
Not this, not it. Taking note of the submission of Mr. Islam, learned counsel for the petitioner, he is allowed to, no, this WPC stands dispose of on withdrawal. Yes, Mr.
My
Sir.
lord, I beg to trouble your lordship over item number 44. It's a mentioned item. By my junior friend had done that. The interim needs to be extended, madam. Yes, I'm good. I'm good.
Appraisal, Lordship, I beg to mention item number 17, Lordship.
17.
17. Matter is in fixer, Lordship.
Infrastructure. Mr. Your name, please?
R.I. Mandal, on behalf of MSN, Lordship.
R.A. Mandal.
R.I. Mandal.
R.I. Mandal, learned counsel appearing on behalf of Mr. M. Hussain. Learned counsel for the petitioner submits that this matter become infectious and as such, he may be accorded permission to withdraw the same. Accordingly, this WPC stands disposed of on withdrawal. Mr. Sharma for respondent authority.
Elementary education.
Okay.
Oblige,
I will take from learned counsel for the state government. State response.
Item number 1, order for implement of party.
May I please, Lordship? Lordship, this, I filed an additional affidavit for implement of contempt number 1, Lordship. Previous contempt number 1 has transferred to some other place. So the present incumbent has taken the charge of this Secretary to the Government of Assam, Lordship. So the petitioner has filed a petition for substituting the contempt number 1, Lordship. Which is registered as IS Civil 2710 to 2024. This honorable court has directed the petitioner to serve a copy of the order dated 26/11/2021, passed in WPC number 868 of 2021, Lordship. So as per the direction of the honorable court, Lordship, the petitioner has approached the authority and filed the representation, Lordship. The representation is,
Okay, let us first implement the parties.
Lordship,
Heart miss your good name.
A Pine, Lordship,
A.
A Pine.
Pine, learned counsel for the applicant. This interlocutory application is preferred by the applicant for substitution of the contempt order number 1 in the instant contempt case number in the contempt case number 370 of 2022. The learned counsel for the applicant submits that the contempt order number 1, Dr. Vijay Soturi, has been replaced by the present incumbent namely Sri Narayan Kumar, Secretary to the Government of Assam, Department of School Education. And in place of Dr. Vijay Soturi, the present incumbent Sri Narayan Soturi is required to be implemented as contempt order number 1. But taking note of the submission of Lord and Counsel for the applicant and also considering the factions in the record, the pair stands allowed. Sri Narayan Kumar, Secretary, School Education Department, being implemented as contempt order number 1 in the contempt case number 370 of 2022. The learned counsel for the petitioner shall file amended post-title in contempt case number 370/2022 in a period of 1 week from today.
Item number 2 for admission, part of matter.
Maybe. In this case, your lordship will directed to produce the original copies of the select list. But I have seen in lordship record, but they have provided me only 1 million protestant copy, and that is same is provided to your lordship also. And no affidavit has been filed. As per office note, Milord, of 29/4/25, that affidavit no affidavit has been filed till date. But I think Milord, affidavit is required so that I can file reply, etc.
So my file here.
Lordship, I will file. Otherwise, it is affidavit is ready. Within a week, you will file. So lordship may fix after 15. In the meantime,
After 15.
lordship, after.
Third method was it learned counsel for the petitioner and Mr. Sharma for respondents in elementary education department. Lord Sharma submits that his affidavit is ready and it will be filed in a period of 1 week from today. That's for listing the matter after 2 weeks. They are allowed placing the list the matter.
It may be Milord 16/5.
16.
Lordship.
16.
Madam, careful for respondent number 5.
Item 3, part of matter. Please, your lordship.
Yes.
Well, can you see last occasion, they handed over a order 26 March 2025. The finance department has accorded its approval, my lord, but till date, no amount has been released, my lord. The area amount entitled to the petitioner, my lord. They are every time taking this or that claim. My lord.
Finance department, who is appearing for finance?
Finance,
Mr. Soliha,
finance already accorded approval.
Yes, Lordship, we, on the last
Finance
date,
already accorded approval, my lord.
Lordship, I have given we have placed a communication on record also that, the proposal was sent and we have already given our approval.
Hmm.
And pursuant to that, Lordship, the education department was supposed to act upon it.
yes,
We will obtain instruction after the concurrence of the finance department.
We've already given.
Already given, my lord. On the last occasion, they have
Mr. SMT.
They have
Chisti is
submitted that
coordinating
within two,
Mr. SMT Chisti is coordinating with the matter. According to him, Lordship, because finance that concurrence was required, now we will obtain instruction. Lordship will fix after 1 week. Mr. SMT.
no, my lord.
If the
Chisti is
concurrence is
available today,
Lordship, he is in court number 1, Lordship.
so let him ask,
Lordship.
let him remain present in the court.
Lordship.
Christie himself,
Sometime let Mr. Chisti come.
Lordship.
Item 4. Item 4.
Lordship, affidavit on behalf of SCRT has already been filed, Lordship.
Right.
Petitioner has
But the
not yet filed
petitioner
any
of the
reply.
previous day also remain absent.
Lordship will wait for the next date, Lordship will decide this. Otherwise, he has not filed any reply, Lord.
No, the question is whether the petitioner is interested to pursue the
Yes,
petition or
That
not.
is the issue.
On previous date also remain. None appears to the petitioner on call, however, Mr. P. Nayak learned.
Standing counsel SCRT, Lordship, preparing for
Standing
response number
counsel,
4 and 5.
SCRT, present. You have filed your affidavit.
Yes, Lord.
Mr. Nayak submits that the respondent SCRT has already filed the affidavit in opposition. But since the petitioner is unrepresented today, recusal is the matter after a week. And in the event of subsequent non-representation of the petitioner, appropriate orders will follow. It is
I'm sorry.
noted here that on 4/4/2025 also the petitioner remained unrepresented.
Lordship, I'm appearing for 1, 4 and 5.
1, 4 and 5.
Not one mistake, Lordship. I'm appearing for 2 and 3.
2 and 3. Okay.
Item number 6.
May I please, your lordship?
Yes.
My lord, this matter, my lord, the subject matter is, my lord, the genuineness of two school, my lord, both the school using the one dashboard, my lord. And our school was established in 1978, my lord. And subsequently, my lord, when, my lord, in the dashboard, my lord, 2019, my lord, our name is reflected, my lord. Then, my lord, subsequently we have found, my lord, the private respondent 9 and 10 using the same dashboard, my lord, they're having another school, my lord, establishment. Then, my lord, what happened? We made an application before the authority concerned, and authority concerned report directed to deputy commissioner to conduct an inquiry the matter and submit the report. But saying in that order, my lord, in the year of 2018, my lord, but what is the outcome of that inquiry? We don't know anything. Then, my lord, when all the schools records submitted for verification of the to enlist all the school for provincial election, we found depriving us the private respondent 992 is reflected in the provincial verification list. Then, my lord, we again made a representation authority. They are sitting silent. We are before this court. We filed this case in the year of 2021, and this honorable court has very fast date on motion that granted interim stay protection, my lord. And this honorable court, my lord, on 12/5/2023, there's a direction, my lord. Kindly have a look at the order. 12/5/2023. That, my lord, since, my lord, there is another prayer for conduct of inquiry, which school is correct. So it is the government advocate council, my lord, to please record the genuineness of our school is genuine or private respondent school running the which one is genuine. That report is very much essential before the to adjudication of the matter. So my humble submission in this case,
So the inquiry report
my lord,
prepared by the deputy commissioner is not part of the record.
it is not part of the, this is one of our prayer, my lord. So what is the outcome of the inquiry? Let them place before this court, my lord. And today, in fact, my lord, the private respondent, my lord, they have filed one affidavit. Today we have received, my lord. We also need some time to reply on that, my lord. Since government advocate were granted time 2023.
Mr. Fukon,
I am for the elementary education, my lord. Since it's a diaspora matter, it is the SSA who is the.
Yes.
But the.
SSA party is
will
there.
decide as to the genuineness of the particular school. The diaspora is maintained by the.
no, the inquiry was conducted by the deputy commissioner.
Deputy Commissioner, my lord.
DC is represented by the.
Page
Yes,
42
madam,
Annexure 8, my lord.
Inquiry report is available. You produce the relevant report furnished by the deputy commissioner after inquiry.
My lord.
Heard Mr. Data, learned counsel for the petitioner, and Mr.
J.M. Sulaiman,
J. M. Suleiman, learned counsel for the respondent number
910.
9.
9 and 10.
9 and 10. Ms. Fukon for respondent number.
1, 2, 3.
Yes.
3 and 7.
1, 2, 3, and 7. And Madam Fukon for respondent number 5 and 8. Mr. Decker, learned counsel for the petitioner submits that the private respondent, the number 9 and 10, have filed affidavit in opposition, and the petitioner needs some time to file his reply
My lord.
to the aforementioned affidavit in opposition. But order Mr. Decker submits that
Page 42 Annexure 8, my lord.
as per order of this court,
No, my lord.
the inquiry was conducted as per order of this court.
No, my lord. Kindly have a look, page 42 Annexure 8.
42.
Yes. On 27/8/2018, will the Executive Director SSA Assam directed the Deputy Commissioner to conduct inquiry and furnish report.
42.
Yes.
That as per direction of the executive director.
Respondent
SSA
4.
SSA Assam dated 27/8/2018. The
Below.
deputy commissioner of Karimganj district was directed to conduct an inquiry.
And also directed for submit report, my lord.
Against false and baseless, allegedly false and baseless record of Adarsa BLP school bearing dice code number 18220428704,
My lord.
headed by Sopan Kumar Devnath. And the said report is not placed on record, and to adjudicate the dispute between the parties,
Yes, my lord.
aforementioned report is required to be placed on record, and as such, Mr. Decker submits that the respondent number,
Deputy Commissioner, my lord.
the deputy commissioner may be, Karimganj may be directed to produce the relevant.
Respondent 5, my lord.
Respondent number 5 may be directed to produce the relevant record before this court. Where is accordingly allowed, Ms. Fukon, learned standing counsel for the respondent number so and so. On next day, place the record before this court. This is the matter after 2 weeks.
3 weeks given, my lord. 3 weeks maybe,
Okay,
yes.
3 weeks.
Deeply authorized. Deeply.
My lord, here in this case, Mr. P. Ali, he is the conduct lawyer. He is out of business in Belur. After
Mr.
3 weeks, matter will come.
Ahmed, learned counsel for the petitioner submits that conducting counsel Mr.
P. Ali Ahmed.
P. Ali.
P. Ali Ahmed.
P. Ali is out of station, and as such, he requested to list the matter after
3 weeks.
3 weeks. They are allowed, this is a list the matter after 3 weeks.
Item 8 and 9.
May I please your lordship? Lordship, my senior is coming. Please time being, my lord.
Okay. Okay.
Number 10.
For 2 weeks time, we granted for, we have instruction on receive lordship. For 2 weeks time, we have communicated lordship.
2021 matter.
And that's true, lordship, that's true. We have communicated, but we ensured lordship. 2 weeks.
First Miss M. Bora,
Lordship.
learned counsel for the petitioner. And also heard Mr.
Yes,
Mia,
please.
learned standing counsel for the respondents in
One
Higher
and four.
Education Department, and Mr. M. Smith for respondent number 3. Mr. Bhuya submits that he has not received the inspection and he tries for granting in some time. There is allowed place to submit the paper after 1 week,
2 weeks, Lordship.
after 2 weeks. After 2 weeks.
Deeply.
Item 12.
Kindly peruse the earlier order, my lord. And thus, Learned Standing Council furnished the copy, my lord, order dated 24 hours. 14 to 16. এইটো বঙাইগাঁও যে আছিলে এইটো তুলতুল বৰুৱা বঙাইগাঁও যে আছিলে আগৰ তাৰিখত দিছিলে সেইকাৰণে
This time April.
Till that, my lord, no, I have not, my lord, no process has been taken, my lord. As per my instruction, my lord. Matter pertains to non-payment of compassionate family pension, my lord.
Mr. Sharma, whether the pension papers were submitted.
In this regard, I have to take instruction, my lord. Some time is required, my lord. Next week, my lord.
The earlier occasion, my lord, letter has been produced, my lord. I think that, my lord, within 13 April 2025.
No, Mr. Sharma, you obtained verbal inspection from the inspector of school, Bongaigaon.
Yes.
Whether the pension papers were correctly submitted or not. Because this letter is updated 24/4/2025.
Yes.
We'll take it up at 2 o'clock.
Yes.
Item 14.
My please, your lordship, the matter relates to the appointment of the petitioner, the post of headmaster lordship. He was a Hindi section Paranga degree holder, and he was interviewed for the post of headmaster. And earlier he approached before this honorable court with a writ petition, that is the order in Annex I have. Annexure 11, page 45. Relevant portion is lordship. Page 51. And this honorable court also directed the secondary education department to proceed with the selection process for promotion to the post of headmaster on regular basis, on the basis of selection lordship. And thereafter, 28 numbers of Hindi section Paranga degree holder were promoted to the post of headmaster, but petitioner's case has been left out, lordship. And while
So
the
Sharma, you were appearing for respondent.
Yes.
Have you filed your oh no, sorry, there's a affidavit in opposition.
no lordship.
My lord, otherwise, my lord, he has already overaged, my lord. At the time of filing this writ petition, he was 58 years. Now he is 60 years and above, my lord. So probably he may be retired, my lord.
But lordship, one thing may be done. I have filed an appeal before the committee, whereby a false complaint was filed by the respondent number 6 against me, and against which I have filed. That representation is still pending, lordship. Your lordship may give a direction to dispose of the said representation, lordship.
That page number?
Page number 57. It was filed on 2021, Lordship.
So if you have already retired from service, what purpose will be served by issuing any direction to appoint you as headmaster?
Sorry, Lordship.
If you have already retired from service, so what
Yes.
purpose will be served by directing the authority to dispose of this petition?
Lordship may give the promotional benefit, pensionary benefit,
Pensionary benefit.
as headmaster. From the day of promotion to other 28 numbers of Hindi section for Angan holder. Lordship.
So page number 57 is the representation.
Yes, Lordship. That is still
So
pending,
this
Lordship.
petition was addressed to whom?
Address to Committee on Petition, Assam Legislative Assembly.
Committee on petition means?
Yes, Lord, I have made party as a respondent number 4. Respondent number 4, and he is duly appeared earlier.
Committee on petition, Mr. Sharma, what is this? It's respondent number 4.
Apparently, I'm not government, my lord.
Pardon?
It is now not related to education department.
Earlier, some A Bhuya Lordship appeared.
A Bhuya.
A Bhuya for respondent number 4.
My friend is it.
My inspection, we have no role in this matter. So number 4, my
Pardon?
the chairman, my lord, as per the inspection, my lord, we have no role in this matter, my lord.
Pardon?
As per my instruction, we have no role in this matter, my lord. Respond
You
number
have no
4.
role.
I'm for respond number 4, my lord.
But this representation at page number 57 is addressed to you.
Then, my lord, I'm sorry, my lord, then I have to take fresh instruction, my lord.
And already he is my lord retired and over my lord selection process also may be over my lord. So
No, he
now
was
new
selected.
selection process.
No,
He
as
was-
per this representation, he was already selected.
Yes, Lordship. And 28 numbers of teachers were already promoted. That is page number 52, Lordship. But petitioner case has been left out because of the complaint filed by the respondent number 6.
Page number 52.
52. This is in pursuance of the earlier order, Lordship. They all are Hindi Paranga degree holder.
Yes.
I have to take fresh instruction, my lord. I'm sorry, my lord.
Oh, you obtain verbal instruction, will pick it up at 2 o'clock today.
Yes, Lord.
What happened about the representation?
Madam 15.
Obliged, Lord.
May I appeal your lordship?
Yes.
My lord, in this case, my lord, affidavit has not been filed by the my lord director and the my lord deputy commissioner. Respondent number 2 and 3 respectively, my lord. Affidavit is required to be filed.
So, Sarma,
Lordship,
are you
we will
interested?
file
to
our
file
affidavit,
affidavit?
Lordship. But these are the schools managed by the tea garden authorities. So slightly different. So our affidavit is also required, and as well as the government's affidavit is also required.
Required, my lord. 2 and 3, my lord. Respondent number 2 and 3.
District Scrutiny Committee, Zurhat, are you representing, madam?
Yes.
So, are you interested to file affidavit in opposition? Heard, Mr.
BK Das, my lord.
Learned Counsel for the Mr. Sarma for respondents in Elementary Education Department. And Madam Popon for respondent number 3N. Mr. Sarma, you have 4 also for District Elementary Education.
I am for also 4 and 5, Lordship.
4 and 5.
1 to 4 and 5.
Okay. And there's a headmaster.
Headmaster, it's a tea garden school, so notice has to go, Lordship. Notice. These are the schools managed by the tea garden authority. It's not a government school.
Notice perhaps served, my lord. That's why the matter has been fixed for admission, my lord.
Pardon?
Notice perhaps, my lord, served, my lord, perhaps. I have not gone through the my lord office note. Matter was fixed for admission, that's why perhaps.
Deemed to have been served. That's one number 7. Service completed already.
Service completed. That's why it has been fixed for admission, my lord.
Learned Counsel for the petitioner and Mr. U. Sarma. No, Mr. P.N. Sarma, Learned Extended Counsel for the respondent number 2.
One to 4 and 5.
Mr. Sarma, Learned Extended Counsel for the respondent number 7. So
1 to 4 and 5.
for respondent number 3 submits that they may be granted something to file their affidavit in opposition. Here is allowed, let's release the matter after 2 weeks.
After 3 weeks, Lordship.
After 3 weeks.
Item
Plus.
16.
My lord, in this read petition, the petitioner is claiming the OPS, my lord, old pension scheme, my lord, but the respondent has not been filed any response till today, my lord. My lord, actually it's a covered case, my lord.
When they were appointed,
My lord, they were appointed prior to, my lord, their appointment has been regularized by the inspector of school in 1992, my lord.
92.
92. My lord, I have annexed the judgment, my lord, here with my lord.
So Mrs. Sarma and Mrs. Soliha, are you interested to file counter affidavit? Yeah.
Lordship, here we will file an affidavit, Lordship, because inspector of school might not be the appropriate authority to grant regularization. Plus, Lordship, if the petitioner is only if the petition falls under the category of stipendary teachers, that has to be confirmed by the education department. Only then he'll be, only then they'll be entitled to the benefits of old pension scheme. So if that information can be gathered by the education department, it's a small issue, Lordship. But if they are not, if he is not, does not follow the category of stipendary teachers, Lordship, then he won't be entitled to benefits of the old pension. Lordship may grant us. 2 weeks time, Lordship, here we'll just identify whether he is falling under that category or not.
Where is the regularization order?
My lord, regularization order is at page 37, my lord. It is in 2014, my lord.
That is 2014, Lordship. So if that is, then he'll be governed by the new pension scheme, Lordship.
My lord, that is regularization, my lord. The petitioners were appointed by the governing body of the school. That appointment has been approved by the inspector of school in 1992. That is annexure, my lord, the 2 at page 30, my lord.
My lord, their school is provincial is on the 1/1/2013, my lord. Yes.
That is after 1/2/2005, Lordship.
That is regularization, my lord. That is correct, my lord. That is not disputed by the petitioners, my
He
lord.
be governed by the old pension scheme, Lordship.
My lord, whatever there's and let them file affidavit.
Heard Mr. Soikia,
Yes, yes, Lord.
learned counsel for the petitioner, Mr. Sarma for respondents in secondary education department, and Mr. Soliha for respondent number in finance department. Respondent number?
4, Lord.
Respondent number in finance department. Mr. Sarma and Mr. Soliha submits that they may be granted 2 weeks time to file their affidavit. There is accordingly allowed. This is the matter of record. After. Madam, you are for? Respondent number 5. Director of pension. You want to file affidavit? No.
My lord, can you fix it that, my lord?
Okay.
28 May,
Oblige you.
item 18.
The petitioner is the retired principal of Regional Health College Guwahati.
Retired?
Principal of Regional Health College Guwahati, and departmental proceeding was initiated against him for taking rupees 2 lakhs from the internee who passed out from other colleges. They want to internship in Guwahati, Regional Health College Guwahati. They said that the making of payment and the cost of expenditure, they should collect 2 lakhs rupees from each person who has enrolled for internship in RDC Guwahati. And that proposal was given by the petitioner. And that is why, Lordship, ultimately government has decided to issue a departmental proceeding that internship should not be collected from the internee, from outside college. And secondly, Lordship, the AMC, annual maintenance contract, has been extended from the time to time, 3 years, as per approval of the DMA. Ultimately, Lordship, penalty has been imposed by the departmental proceeding. Lordship will find at page 101. Page 101 is the order of penalty dated 29 March 2022. Lordship got it? Now, Lordship will find at the last portion, 104. Now, therefore, government in Health and Family Welfare Department hereby impose penalty of reduction in lower service rate or post or to a lower time scale or to lower stage of time scale under Rule 7(5) of Assam Service Discipline and Appeal Rules 1964 upon Dr. A.K. Odhyapak with effect from date of superannuation 5/1/2018. He has superannuated on 5/1/2018. Now, Lordship,
May I interfere, my lord? I need some time to obtain instruction, my lord. I have not received the instruction, my lord.
my submission to be Lordship, if Lordship permit. Petitioner has taken loan of rupees 40 lakhs before his retirement for construction of his house. He is not in a position to pay the loan. He become now, Lordship, the defaulter in case of bank loan. 40 lakhs has been taken loan from the bank for construction of his residential house. For not releasing the gratuity and the other leave encashment benefit till today, gratuity and leave encashment benefit has not been released. Lordship is aware that as per Gratuity Act, Lordship will find.
My lord, to that effect, may I submit that your lordship may observe that whether the leave encashment and gratuity may be released or not. On that also, my lord, I will obtain the instruction.
Because Lordship, in this particular case,
Your lordship may fix after 10 days or next week, my lord. I will obtain the
Lordship, I have no objection to the prayer. Only Lordship will take the instruction regarding gratuity because gratuity can be withheld. Gratuity can be withheld. As per section 4 of the Gratuity Act, gratuity should be released within 30 days from the date of superannuation. And gratuity can be withheld only on 2 grounds. When he is terminated from service, or Lordship will can, may I read Lordship? Notwithstanding anything contained in subsection 1, gratuity of an employee whose service has been terminated of any act, willful omission, negligence causing damage, loss, or destruction of property belonging to the employer shall be forfeited to the extent of the damage, loss, and cost. After termination, that can be done. I have not been terminated. Only Lordship reduction in rank. My appeal is pending before the governor. Appeal also not disposed of till today. This honorable court directed to give the provisional pension, and provisional pension has been released now. It is only 34,000. I have to pay the monthly to around 45,000 installment to the bank. For not releasing this amount, Lordship, I am become defaulter. I am suffering. I am a retired principal. Gratuity should be released, Lordship. At least gratuity, Lordship. They will endeavor to make the gratuity, Lordship. At least.
Oh, why you are withholding it
Yes, my lord, I will obtain instruction to that effect also. my lord.
today?
To that effect, my lord, whether gratuity can be released or why it has been withheld. my lord.
Till date, Lordship. 2018, I have returned. It should be released.
No, better you do one thing. You obtain verbal instruction why the gratuity of the petitioner is being held up.
Yes, my lord.
At 2 o'clock, you inform this.
My lord, today it is not possible. I have already.
Why not possible?
I have called the officers. They have been deployed outside Guwahati due to some election duty or something, my lord. I have called them, my lord. That's why, my lord, I have prayed,
So,
my lord.
Bora, you say,
I
if
understand.
you are, if
I understand, my lord. It's a matter of hardly 10 or 12 days, my lord. I will obtain your lordship may observe that in the order also I will communicate whether the gratuity, why the gratuity has been withheld and whether it can be paid or not. I'll obtain instruction to that.
no, why it could not be paid?
This for act part, it should be released.
Actually, my lord, probably there is an inquiry going on also, my lord.
But inquiry, punishment is already imposed.
Yes, my lord, but due to some financial irregularity, my lord. I'm not sure, my lord, so I will obtain
No, Mr. Bora, you see this page number 104, punishment has already been imposed upon him.
Yes, my lord, I understand, my lord.
Then, how many inquiries are going on?
After retirement. After retirement.
My lord, yeah.
It will.
So page 101, my lord, if that order, my lord, if your lordship peruses, there is, whereas the Directorate of Financial Inspections was directed to conduct detailed inquiry into financial matters, expenditure of RTC, including the Hospital Management Society, covering the last 5 years, in order to verify the compliance with government financial rules, and at same time, DME was also directed to conduct an inquiry into all the aspects of the functioning of the college. So probably that inquiry is also going. Anyways, my lord, I will obtain the instruction regarding the gratuity and leave encashment, my lord. Today also I tried to obtain the instruction, verbal instruction, but since the officers are out of station, my lord, so I could not obtain the instruction. I called them.
Monday there.
Monday, my lord, Panchayat election is there. That's why they have been deployed for the election duty, my lord.
Okay, let it be after 10 days.
Yes, my lord.
Lordship may record that why
Your
gratuity.
lordship may observe regarding the payment of gratuity and leave encashment.
Okay.
And there is no bar for release within time, Lordship.
Art Mr. S.K. Goswami, learned at Council Protocol, and Mr. D.P. Bora, learned at Council Protocol, respondent number 120. Being the authority under Health and Family Welfare Department, Dr. Basan. And for Finance Department, Mr. Solia, respondent number 4. And Madam, you are for R.K. Talukar, respondent number 4.
5.
Being the Accountant General A.N. Assam. Sir, Goswami learned counsel for the petitioner submits that the petitioner already retired from service on superannuation in the year
2020
and till date gratuity and
leave encashment benefit.
leave encashment benefit has not been released by the respondent authorities. Mr. Bora learned counsel for the petitioner. No, sorry. The respondent number 120 submits that he may be granted some time to obtain necessary instructions in this regard. Where is accordingly allowed or is the matter after 10 days on
21st May.
21st May. 21st May. The meantime, Mr. Bora shall obtain necessary instructions as to why the leave encashment and the gratuity is not paid to the petitioner. It's according.
Also, pendency shall not be barred to release, Lordship, within time. 10 days, they can release also.
It is being clarified that pendency of the petition not be a bar in releasing the aforementioned benefit to the victim.
Obliged, Lordship.
Item 19.
Non-appears for the petitioner on call, lays the matter after 1.
20.
May I please, Lord? My Lord, here is a case, my Lord, Lordship will find, my Lord, the very limited prayer before your Lordship. Lordship kindly see the, my Lord, page, my Lord, 37. Now, he has been provincialized in service, but base school should be Nailga LP school. In place of Nailga LP school, it has been mentioned, my Lord, Andamari LP school, which is 14 kilometer distance from his house. Now he made an application before the competent authority. Lordship will find that has been provided also, page 37. My Lord. 37.
Yes.
This is issued by the my Lord, block elementary irrigation officer to the district elementary irrigation officer.
Yes, sir. For 10-kilometer distance,
And my Lord,
is there any bar in the act?
now under the my Lord, Act, my Lord, section 2D, the nearest school, nearest provincialized school should be the base school. That is there.
Nearest.
That is
Yes.
there.
What is the nearest school?
Yes.
No. What is the nearest school to your school?
My Lord, Nairalga LPC.
Nairalga.
Yes. Which is 2 kilometer distance.
Pardon? 2 kilometers.
2 kilometer distance. Now I have been, my Lord, attached in a school which is 14 kilometer distance from my residence. So as per section 2D, my Lord, it should be the nearest school, that is Nailga LP school. My friend who also, my Lord,
Lordship, there is a definition of base school, Lordship, where it has been specified. Base school means section 2D of 17 Act. This is number 102, Lordship.
102. Yes.
2D, D, Lordship. Base school means either an existing provincialized or a venture educational institution identified for the purpose of provincialization of services of teachers and of their tutors, as the case may be, within the radius of 1 kilometer in case of lower primary school, within the radius of 3 kilometers in case of upper primary school, within the radius of 5 kilometers for high school and 7 kilometers for higher secondary or junior college, and which possesses satisfactory norms and standard in relation to enrollment of students, adequate infrastructure, and having DICE code for the year 9-10. These criteria are also there. It has to be within the radius of 1 kilometer, 2 kilometer, 3 kilometers in respect of LP and upper primary. But these criteria has also to be fulfilled, that they must be having the requisite satisfactory norms, standard relation to enrollment of the student, adequate infrastructure, and having DICE code. So these requirements are there. Otherwise, Your Lordship, there is a representation also, page number 38. Your Lordship, and direct dispose of this petition with the direction to the Director of Elementary Education Operation of the Director of Elementary Education for this passing a reason order by disposing of this representation. Page number 38 is the representation. Lord.
Page number
38.
The director will pass a region order by disposing this representation laws. They will verify.
Heard Mr. Mandal, Learned Counsel for the petitioner, and Mr. Ian Sharma, Learned Standing Counsel for the respondent of heard this. The grievance being sought to be addressed in this great petition under Article 226 of the Constitution of India is that by order dated 5/2/21, the service of the petitioner has been provincialized as per the provision of the Assam Education, which indicate provincialization of services officers and reorganization of educational institutions, Act 2017. 2017. Where is that order, Mr.
Provincialization, my lord.
Yes.
Page 32, my lord.
Page number 32, Lords.
31 or 32?
32.
Page number 32.
32 is the my lord, original, my lord. And 31 is the my lord, type copy, my lord.
Where no, white annexer 31, no, white annexer 9 at page number 31, wherein the base school is shown as 2041 number Anandamari LP school in place of
Andamari LP School.
Andamari LP School.
Andamari, okay. In place of
In place of my lord,
1386 numbers of Nair Alga LP school,
My
in
lord.
respect of the petitioners. P. Hasani Para LP school. Hasani Para LP school. Yes, sir. Mandal Learned Counsel for the petitioner submits that the said school is situated at a distance of 14 kilometers
my lord.
from the present school of the petitioner. Present school of the petitioner. And in view of section 2D of the Assam Education Provincialization of Service of Teachers and Reorganization of Education Act 2017, it should be page number 10, Mr. Sharma.
Lordship.
Page number 10,
2T.
base school
102, Lordship.
102.
102. Base school.
It is, Mr. Mandal, it is a lower primary school or
Lower primary.
lower primary school. And in view of section 2D of the said act, base school means either an existing provincialized or a venture educational institution identified for the purpose of provincialization of service officers, instruct tutors, as the case may be, within the radius of 1 kilometer in case of lower primary school, and within the radius of 3 kilometer in case of upper primary school, and within the radius of 5 km, the high school or high madrasa, and within the radius of 7 kilometer in case of higher secondary school or junior colleges. And which possess satisfactory norms and standard in relation to enrollment of students, adequate infrastructures, and having the spot of the year for the year 2009 test, 2010 or before, and as the school of the petitioner is as the base school of the petitioner is situated at a distance of 14 kilometers from the present school of the petitioner. The petitioner has filed one representation.
Lord, first application, Lordship will find at page 35. Page 35.
Filed one representation to the district elementary education officer, to the block elementary education officer on 38/11/2021.
And second one, my lord, 10/8/2022.
Thereafter,
Page 38.
and thereafter he had filed another representation on 10/8/2022
By register post office.
to the Director Elementary Education, Assam, Kailipara, Guwahati, and the said representation is yet to be disposed of. And as such, Mr. Montal submits that this writ petition might be disposed of by directing the respondent. By directing the Director Elementary Education, Assam, Kailipara, Guwahati, to dispose of the representation, keeping in mind the provision of section 2D of the Assam. So Sarma learned standing counsel for the respondent authorities also submits that
2, 3, 4, and 5.
2 and 3. Then is on the spoken for respondent number 1. Respondent number 1 also submits that the respondent authorities may be directed to consider the representation filed by the petitioner dated 10/8/2022 in terms of the provision of section 2D of the Act of 2017. 2017. Taking note of the submission of learned counsel for both the parties, I have carefully gone through the petition with the record also. Where is the representation dated 10/8/2022 filed by the petitioner addressing the Director Secondary Education Assam. Taking note of the submission of learned counsel for both the parties and also considering the facts and circumstances of the record, and also the definition of basic school as defined in section 2D of the Act of 2017. This court is inclined to dispose of this writ petition by directing the respondent number 2.
3 minutes.
Respondent number
3.
Respondent number 3. Respondent number 3. To dispose of the representation dated 10/8/2022 filed by the petitioner within a period of 1 month from the date of receipt of certified copy of this order. Certified by a region order, keeping in mind the provision keeping in mind the definition of basic school in section 2D of the Act of 2007. terms of evaluation of the conditions.
Developers.
Item 21.
May I please, your lord?
Yes.
My lord, the matter relates to, my lord, initiation of a departmental proceeding. My lord, alleging that I am my lord, I was unauthorized absent for a particular period, my lord. My lord, actually what has happened, my lord, I have tendered my resignation for my health condition, my lord, and thereafter I could not continue. But now with an affidavit, my lord, the health department has come up with a plea that the resignation letter which I tendered, my lord, was not through proper channel. But now they have come to know that I have tendered the resignation, my lord. So, my lord, my respectful submission before my lord is that as I have tendered my resignation, now it is their duty, my lord, either to accept the resignation or, my lord, they can reject it also. So, my lord, in that line, my lordships can dispose of my petition, my lord.
Yes, madam.
Lordship, I'm praying for 10 days time to get updated instruction.
Affidavit has already been filed, my lord. There is nothing for the
If
inspection, my lord.
affidavit is filed,
My
then
lord, long-
what instruction you are required to
File.
place on record?
affidavit দিছো তো আপনার ফাইল নাই আপনার লগত এটু লৈ লওক The affidavit, they have taken a categorical stand, my lord, that the resignation which I did submit, my lord, was not through proper channel, therefore it could not be locate or something like that, my lord. So therefore, my lord, as they are now within the knowledge that I have, there is a resignation I have tendered.
So, where is Mr. Bora?
Lordship, Mr. Dew Pomano is in,
Pardon?
Lordship, I'm for the health department. I'm appearing on behalf of Mr. Dew Pomano.
Pardon?
My lord, my learned
everyone-
friend is appearing on behalf of standing council held D. Opamano, my lord. Her submission is that he is in some other court, my lord, on leg, my lord.
Let him come.
My lord.
Lordship, this matter may be taken up on Monday, Lordship. By then, Lordship, the instruction when the representation and how much time it can be, in how much time it can be taken to dispose of the representation, Lordship. Lordship,
lord.
just has it on Monday, Lordship.
Monday.
Yes. Lordship, we just
Or my lord, not Monday, my lord. Can it be on Wednesday or Friday, my lord?
We'll just seek the instruction
My lord.
when it can be. how much
As
time it
agreed by learned advocates of both the parties, let's lead the matter on Wednesday. In the meantime, the respondent authorities shall.
My lord,
obtain
7th is a
the-
holiday, my lord. Can it be on Friday, my lord? 9th, my lord.
In respect of the present status of the representation, resignation letter filed by the petitioner on.
My lord, submitted the representation, my lord, on, my lord. My lord, that representation is not here on record, my lord. But the resignation letter, my lord, I have annexed, my lord.
Page number?
My lord, the page number, my lord, may be pleased to find. Page 23, annexure 3, my lord. No. Page 24, annexure 4, my lord. Sorry, my lord.
24. In
My lord.
respect of the
Resignation dated 10/10,
letter dated
my lord.
10/10/2017.
2017, my lord.
On next that, please the matter on Friday.
Friday, my lord. My lord. 9th, my lord. Oblige.
22.
None appears for the petitioner on call. How about Mr. Sharma, learned standing counsel to the respondent elementary education department and Madam Cooper for respondent number. Respondent number 3 present. Please the matter after 1 week. In the event of subsequent non-representation of the petitioner, appropriate orders will follow.
23.
Same or better.
24.
Non-appearing for the petition or on call, how Mr. Bora, learned extending counsel.
Respondent.
SCRT.
Yes, respondent.
Respondent number?
5.
5. Respondent number 5. Mr. Popon, you are call?
I'm for the 1, 2, and 3.
1,
1, 2, and 3.
1, 2, and 3.
My lord, elementary education.
1, 2, and 3 present. Please the matter after.
Mr. Solia is there for respondent 4. Solia, yes,
We
Solia.
have for respondent number 4.
My friend is there.
In the event of subsequent non-representation of the petitioner, appropriate order to follow.
25 and 26.
Question is on leg. After some time,
25 and 26.
it may be taken after. some-
No, sir, in fact, our instructions are awaited, your lordship. It's the regarding setting aside of the notification, your lordship. At page 70, your lordship.
Oh, sorry, my lord. My lord, item number 26 and 47 also similar and pertaining to the same issue, my lord. Here in this set of cases, my lord, the petitioners are claiming their upgradation of the salary in the minimum scale of pay at the rate of 2017, my lord, ROP. But that is not provided. They have not filed their affidavit. NC Hills Autonomous Council and the government in the education.
Who is for NC Hills? You.
Not for education department.
NCL is supposed to be are supposed to file their affidavit. my lord.
TN4. You are for TN4. Or Mr. Professor, Lord at Council for the petitioner and Mr. Musahar for respondent number
1 and 2.
1 and 2. And Madam, your good name, please. For respondent number 3 and 4. 3 and 4. Then Madam Fukun for respondent number 6. 6 and 9. 6 and 9. Ms. Musahar submits that instructions are awaited. And they will listen the matter after 2 weeks. After 2 weeks.
A date may be given, my lord. In respect of three cases, my lord, date may be given.
They are allowed. Please the matter.
28.
25, 26 and
Item 47, my lord.
47. Okay.
These are all right, my lord.
47.
46. Same issue.
File affidavit. Minute. Whether respondent number 8 and 9 appeared.
The same respondent in the other, my lord, cases, item 25 and 26. Yes, finance department, my lord, and the government. Same respondent.
Item 49. My lord,
The secretary
affidavit
learned
has not been furnished.
both the parties.
It has been filed by the respondent number 300, Director of Education, Borderland.
47. Yes.
My lord, this affidavit is what to have been filed, but it is not filed as per direction of the last occasion.
You receive instruction. Or Mr. DCC Popon, learned and counsel for the petition. Is open or respondent number. Madam, you are for respondent number
Number 5, your lordship.
Respondent number 5, Director of Pension, and for rest of the respondent, elementary education.
Sorry,
Mr. 64, respondent number 2,
Lordship, 1, 2, 3.
1, 2, and 4.
1, 2, 4.
1, 2, and 4.
Yes, sir.
And for Director of Education, 4-line PTC.
This is Shantanu Bora. I will inform Lordship as Bora name make and
S. Bora.
as Bora.
Sir, Bora, S. Bora 4, respondent number.
কিন্তু আপোনালোকে জানিব মোক এনেকে
Respondent
মই
number 3.
পেঞ্চনৰ কথাই কৈ আছো মই এডুকেশ্যন পেঞ্চনেতো দিয়া নাই
It's spoken
Pensioner
granted
Diana.
a standing council for the respondent number 5 submits that she may be granted, no, she has received instruction and she will file affidavit in opposition. Whether the elementary education will file.
Lordship, if it's a basically pension department, they are supposed to sanction the order. Anyway, I would, if necessary, I will file it with Lordship.
Okay.
Otherwise, they have to comply with
only only grievances
and
with
their
the-
grievance against the pension only.
only grievances against the pension because they have furnished a photocopy of my service book. And it is their service book. They stated that the service book is not found. Original service book is not found. So my prayer is that let it be considered on the this photocopy manual. It is their photocopy and it is their burden. They have to look out where it is.
Let the affidavit come.
Yes, yes. Yes, sir.
List the matter after 1 week, madam. After. Fixed that court.
But in the last occasion, it was observed that the in absence of the affidavit also will be considered. And that observation may be continued.
Okay. Mr. Popon, learned counsel for the petitioner as a petitioner referring to the order dated 28/4/2025 submits that on that day, an observation was made that in the event of failing to file affidavit by respondent authorities, the board will consider to hear and dispose of the petition without affidavit. The respondent authority. In view of above, it is provided that in the event of failing to file affidavit in opposition before next date, the court will proceed to hear and dispose of the petition without the affidavit.
But matter, my lord, because I am waiting from 1999, my lord. I retired, yes, my lord. This is an old pending, my lord. My age is about 86 years now.
You have not received the pension.
Not, pension is receiving in the old scale, my lord. My promotional scale has not been provided.
Only the difference. It will do.
Obliged, my lord.
For bail hearing, item 27 and 28.
May it please the lordship. On the earlier occasion, my lord, the learned PP was to produce instruction as to whether at the time of arrest, my lord, 47 and 48 notice were provided or not. That much, my lord.
At that point of time, it was under 50 CRPC, my lord. I have trademark, my lord, regarding that only information, like only that notice earlier part, what they have supplied, not giving the without the grounds.
Grounds of arrest.
That details are not there. Notice was there, my lord. I have trademark only in the record, my lord. Otherwise, commercial quantity case, my lord, and since 23. FR of 31st of August 23. And there are 18 witnesses in the charge sheet. till 7th of January, 13th were examined. But latest has come, but that latest is up to 7th of January. And regarding that,
No, on the other day, Sir Porthakur has ordered one decision of Supreme Court where it is stated that that order will have prospective effect.
prospective,
That order is available with you.
not right now, may fix after some time, I'll.
Okay,
bring
at
that.
2 o'clock.
I live with that.
Item 2930.
Lordship, matter kindly pass over for the time being. My senior is busy in another.
Pardon?
Yes, Lordship.
Who will appear?
Learned Counsel Jesse Gold.
Is he?
Gold.
Yes. He is not present now.
Another, busy in another court.
Lordship, in the meantime, I may start. It will take long time to be here because I have some urgency. It will require some time.
Lordship, I have been only instructed to request for the time being.
Let Mr. Kaur come.
Last
We are ready to hear you.
last time also did not reach.
No,
Anyway.
no, as soon as Mr. Gaur is available before the court, we will start.
Item 31.
May I please, Lordship? Lordship, I'm on behalf of Mr. M.H. Ahmed, Lordship.
Mr.
M.H. Ahmed, Lordship, due to his health issue, Lordship. He is unable to come to the Lordship. Kindly matter may be adjourned for the day, Lordship.
Is there your good name?
I am in Lordship.
Learned Counsel appearing on behalf of
M.H. Ahmed.
A.H. Ahmed, Learned Counsel for the conducting counsel for the petitioner. Made a request to stand over the matter for the day. Fair stands allowed. Unless the matter after 1 week. Yes.
Actually, after 2 weeks, Lordship.
After 2 weeks.
And my submission that both the respondent, they were retired long back, Lordship. So there it's better for them to.
Yes, we will implement, Lordship. We will communicate with them.
Okay, we will do.
Oblige.
32.
Lordship, matter relating to non-compliance of order dated 60/2017, passed in WPC number 5341/2015. Lordship.
Yeah, I have appeared for Rasan number 3, but he was expired, Lordship, long back, Lordship. Yes, Sanjay Kumar Bhuya. And all the respondents, Lordship, others I don't know. Respondent 3 has expired and 1 has been retired 4 or 5 years back, Lordship, already.
Respondent number?
At 3, I'm appearing on Sanjay Kumar Bhuya. He is expired, Lordship. And as far as my knowledge is concerned, Vikram Saikia, Lordship, he has been retired 3 years, almost 3 years back.
So you take step to get a newly.
Lordship, Lordship, I have to implement.
Art Minister, your good name?
P. Boregi. P. Boregi.
P. Boregi. Learned Counsel for the petitioner and also Art Minister. 60.
For
respondent number 5.
3, Lordship.
3, respondent number 3. Mr. 60 submits that respondent number 3 suffered demise about 4/5 years back. Respondent number 1, Pritam Saikia, also retired from service. The Learned Counsel for the petitioner submits that he will take a necessary step to replace the new incumbents in place of respondent number 1 and 3. and he pays for granting him some time. There is accordingly allowed, this is at least the matter. After to it. This is 2017 matter. Take a step.
May it please your lordship. This contempt petition has been filed for non-compliance of order dated 23/2/2017, my lord.
Yes.
My lord, in this order, my lord, direction was given to the respondents, my lord. Inspector of School Udalguri and Inspector of School Dorong to make joint inquiry as required by the earlier order of this court dated 23/4/2001 and pass appropriate order, my lord. In this earlier order, my lord, 23/4/2001, my lord, this court directed the respondents to verify the claim of the petitioner, my lord. If he is entitled for the salary from 1996 to till his retirement, my lord, the salary may be paid to him, my lord. This was the direction in 23/4/2001 order. And now this order, my lord, this is also not complied by the respondents, my lord, till date. And the petitioner herein, my lord, is of 70 years age, my lord. And he is bedridden, my lord.
Lordship, here I am appearing for respondent number 7, who has already retired 3 years back, Lordship, Pritam Choikia, Commissioner and Secretary. And in respect of the other respondents, Lordship, other councils are there, Lordship. Other councils are there in respect of other respondent. I appear for only respondent number 7. And he has retired from service 3 years back, Lordship.
Who is appearing for respondent number 1, 2, RC Zain and P is
Respondent 7. One
Yes.
retired prior to that, more than 8 years back. He was replaced by, I think, by young.
7.
7.
7. And Dijung, respondent 2 was also retired from the long back.
So you include the name incumbents.
Yes, my lord. I will file an implement petition, my lord.
Heard, Mr. Your good name?
S. Upadhyay, my lord.
S.
S. Upadhyay, my lord.
Upadhyay.
Yes, my lord.
Learned
In the meantime, let them obtain instruction, my lord.
Learned Council Court of Petitioner and Mr. Chowdhury for respondent number 7. And Mr. 64 respondent number?
No, I'm not, my friend, no, I'm not here, though.
Okay.
I'm appearing for 7, Lordship.
7. Mr. Chowdhury, Learned Council for the respondent number 7. Submits that respondent number 7 retired 4 years back.
3 years back, Lordship.
3 years back. The Learned Council for the petitioner submits that he will take necessary step to implement the new incumbents in place of respondent number 7. Here is accordingly allowed.
Myself.
What instructions are supposed to receive by you
Whether the joint inquiry was held or not.
as per direction of this court?
Direction of this honorable court's order dated, my lord. Last order. This is the order, my lord. At page 12, my lord. 23/2/2017, my lord. Page 12, my lord.
23/7,
23/2/2017, my lord.
page number?
Page number 12, my lord. Direction is at page 15, my lord.
Lordship, those were in respect of the BTC area. Lordship, it will be better within a short time if he implicates the Director of Education BTC and the new incumbent of commissioner. Lordship, then Lordship, if not, if yet to be done or something is there, that will come up, Lordship instruction. To my knowledge, respondent number 4 has also retired, Lordship.
Okay, you applied all those documents. First, thereafter we'll ask them to furnish a repeated info and instruction. Leave the matter after 2 weeks. After 2 weeks.
Deeply obliged.
Item 34.
Well, in this case, my lord, I am not there is no any communication with my client, my lord. So, my lord, sometime, my lord, I'm going to write a letter to the.
Okay.
I think she is going to retire. I think. At least 2 weeks time, maybe.
3 weeks. There.
35.
Later.
My learned friend was to apprise the court about the.
Here, Lordships, this matter was last taken up on 28/4/2025. On that day, my lord, I was directed to take instruction. Before that, Lordships, on 8/4/2025, to pay the pro rata pension, Lordships, the petitioner had to submit the original service book. Lordships. And that service book she has submitted before the Assam University when she was working there. So on 8/4/2025, the inspector school has written a letter to the registrar Assam University to return that original service book. And on 13/4/2025, a copy was served to the husband of the petitioner. Husband of the petitioner used to come to the office and for regular correspondence. And petitioner husband was aware of that service book was to be submitted before the inspector school. And that submission was not submitted before the Honorable Court on 28/4/2025 when this matter was taken up. And he said that nothing was done.
Lordship, the service book is with the Assam University, Lordship.
It is also on her part, Lordship, to pursue
Assam
that.
University is party here, respondent number 1, Lordship. So, the Assam University should.
We have not received that communication whether we have submitted the service or not.
It was written to the registrar Assam University and also copies up to the petitioner Lordships on 13/4. And matter was listed on 28/4. And this information was not placed before the Honorable Court by the petitioner Lordship.
So, furnish a letter to him.
Yes, I will write now, Lordships.
You obtain instruction let the matter be.
After a week, Lordships. On Wednesday or next Thursday.
Okay, Wednesday.
Yes.
Next Wednesday,
Yes.
holiday.
Yes. Oh, Wednesday holiday. Oh, yes, Friday.
Then next Friday. One thing. That's all. Nine.
Yes. I'll submit a copy right now, Lordship.
Okay. Third Mr. P.K. Das, learned counsel for the petition. And Mr. Sisti for the number.
Lordship, I am for option number 2,
2 and rest of
and 4.
2, 3 and 4.
Yes.
And Mr.
E. Jain on behalf of
S.C.K.S. Jain, learned counsel appearing on behalf of Mr. S.C.K.L. learned standing counsel for the Assam University. Mr. Sisti, learned council product conceptual number so submits that he has submits that prorated pension to the petitioner could not be granted due to absence of the original service group, which has already been sent to the register to the Assam University, to the register Assam University. The learned counsel appearing on behalf of Mr. S.T. Kayal, learned counsel for the respondent in Assam University submits that he may be granted some time to receive instruction as to the present status of the information service. Here is accordingly allowed. This is the matter on 9th. A copy of the letter produced by Mr. Chisti shall be furnished to Mr. Jain, learned counsel appearing on behalf of Mr. Kayal, so as to receive necessary instruction from the respondents in Assam University. Place the matter on. The letter produced before the court shall be part of the record.
37. 37.
His Lordship, service of respondent number 5 has not been served, Lordship. So I may be allowed to, one next time to take fresh steps after taking proper address of respondent number 5, Lordship.
Mr.
M. Rana.
M. Rana, learned counsel for the petitioner, submits that he may be granted some time to take fresh step of respondent number 5.
5, Lordship.
Respondent number 5. Miss.
I thus on behalf of the Upamanna. I thus on behalf of Mr. D. Upamanna.
The Upamanna learned standing counsel for the respondent, authority in higher education department.
Yes, Your Lordship.
Mr. Islam learned counsel appearing on behalf of sir. PJ Pukan, learned counsel for the respondent number 3. Standing counsel for the respondent number 3. And for rest of the respondent,
Respondent number 4.
Christian College. No.
Respondent number 4 has been served and he has appeared, Lordship.
Okay.
His name shown as J.K.
Done appears for the
Parajini.
respondent
Respondent
number
4.
5. To take a step forward. List the matter after correct. Step be taken by registered post with AD and also by usual process. We can wait from today.
Problem.
38.
Make your lordship. Madam, this matter speaking order has already been passed. And it is complied already, my lord. But he has some objection and regarding that he has kind of one additional affidavit. My lord, in this regard, the court is there. If he has some objection regarding the order, then he may.
Your lordship may kindly, may I read the last order submitted by my learned friend. Your lordship may kindly see page 49. Page 49, may I read the order? This is my additional affidavit. Yes. Peruse Honorable High Court's order dated 5/1/24, passed in WPC number 7311/2023, filed by the Rajpur High School versus State of Assam and others, wherein it is stated that this writ petitioner stands disposed of, directing the Director, Secondary Education Department, Government of Assam, to expeditiously place the case of the petitioner in the next meeting of the State Level Scrutiny Committee, and thereafter, basing on such recommendation, necessary order for provincializing the services of the teachers of the school in question be issued at the earliest. The matter of the Rajpur High School was placed before the State Level Scrutiny Committee meeting, which was held on 29/2/24. In the said State Level Scrutiny Committee meeting, the committee, by its resolution number 2 under point number 6, did not recommend the name of the Rajpur High School for provincialization due to the fact that, as per report received from Secretary Seba, only 22 students appeared in the HSLC examination during the year 2015, whereas the minimum students required to appear is 25 as per section 3(5) of the Assam Education Provincialization of Service and Reorganization of Education Institution Act 2017 as amended in 2018. Section 3(5) states the venture education institution has a minimum total enrollment of 25 students,
in class 10. In view of the above facts and as per resolution of state level scrutiny committee, the claim for provincialization of the Rajpur High School cannot be considered. And thus the Honorable High Court's order dated 5/1/2024 passed in writ petition number 7311/23 is complied with. May I take your lordship here to page number 41, para 7. Para 7. May I read your lordship, para 7. That paragraph 7. That in this regard, your humble deponent begs to state that the order number so and so dated 18/4/24 passed by the respondent contemner is merely based on the report received from the Secretary Seba is wholly baseless and incorrect in view of the fact that it has misinterpreted and misconstrued the meaning of section 3.5 of the Assam Education Provincialization of Services of Teacher and Reorganization of Education Institution Act 1917. This section 3.5 of the said act reads as, the venture education institution has a minimum total enrollment of 25 students in class 10 if it is a venture high school. But whereas in case of this deponent oblique writ petitioner schools, it has given different meaning to this section as it has failed to distinguish between enrollment and appeared, thereby giving same meaning to both the term, which is most unwarranted and not at all justifiable in the eye of law, inasmuch as both the term enrollment and appeared have two different meanings, and hence has intentionally and deliberately misconstrued the term enrollment with appeared. Now next para, your lordship, that your humble deponent most respectfully states that in the context of HSLC examination, enrollment refers to initial registration process, where a student joins the school for class 10, while appeared simply means participating in the actual exam. To be more meaningful, enrollment is the act of formally becoming a student at a school, typically in class 9 or 10, which leads to being eligible to sit for the HSLC exam, and whereas appeared means that students participated in the HSLC exam, which signifies sitting for the exam and attempting the questions. Therefore, it seems from the mere reading of the order number so and so dated 18/4/24 passed by the respondent contemner that it has willfully and deliberately misinterpreted and misconceived the term enrollment with that of appeared, knowing fully well that petitioner schools has otherwise satisfied the said eligibility criteria laid down in section 3.5 of the Act 2017, as the Rajpur High School has total enrollment of 35 students in class 10 during the year 2015. Moreover, it is correct to state here that in the year 2015, total number of students appeared in class 10 is 22. That is correct. But however, interestingly, they have intentionally misinterpreted the term appeared with enrollment, thereby trying to mislead this honorable court, which is highly unwarranted in the eye of law. It is pertinent to mention herein that as per the school record of HSLC result for the year 2015 to 18, prepared by the headmaster of the Rajpur High School, clearly reveals that during the subsequent years, that is 2016, 17, and 18, the number of students appeared in HSLC are 39, 38, and 39, whereas the numbers of students enrollment in class 10 for the said subsequent years are 43, 43, and 54 respectively. Moreover, for the better understanding and convenience of this honorable court, your humble deponent petitioner submits a copy of the list containing the name of students, their father's name, including their registration number, prepared by the headmaster of the Rajpur High School, who were enrolled in class 10 for the year 2015, and as such, in view of the aforesaid discussion based on records, it establishes the fact that Rajpur High School has fully satisfied Section 3.5 of the Assam Education Provincialization of Service of Teachers and Reorganization of Education Institution Act 2017 and are very much eligible for provincialization, as it has total enrollment of more than 25 students in class 10 for the year 2015 as well as for the subsequent year 2016, 17, and 18 respectively. In this regard, this honorable court may call for records to justify the correctness and authenticity of the aforesaid statement. Now, your lordship, may kindly say Annexure 10. Annexure 10. Annexure 10 is the list prepared by the headmaster of the school, showing the year 2015, 16, 17, and 18 enrollment in class 10. As per Act, enrollment should be 25. Here it shows 35, page 50. And 1643, 1743, and 1843. And appeared is shown as 22, 39, 38, and 39. So they have confused the term appeared with enrollment. Now may I take your lordship to again page number 44, para 9. Para 9. That Your humble deponent petitioner most respectfully states that with a view to deprive the petitioner's high school from grant of provincialization under the said Act 2017, the respondent
Mr.
contender.
Sharma,
Yes,
whether the contender understood the meaning of the word enrollment and appeared.
My lord,
for that they have chosen the year 2015 to confuse the two terms.
As per order, my lord, they placed the matter state level scrutiny committee, and state level scrutiny committee recommended, did not recommend the name, as because their students were appeared only 22 students in the SSLC.
Only?
Yes,
Only?
only 22
22.
students.
22. So what
Yes.
is the requirement?
Requirement is enrollment, your lordship.
Letter.
Yes, enrollment, not appeared.
So if they have any grievances, my lord, they can.
No,
file another.
you will misinterpret the order and thereafter circumvent the court order. Is it permissible?
Lordship may kindly see the act itself. 3.5 speaks about enrollment, not appeared. And my enrollment is 25 in the year 2015. I have annexed annexure 10. And moreover, your lordship, may I read para 10 also? This will more clearly visualize the matter, your lordship.
I'm
Para 10.
asking something to
Okay,
him.
yes.
Let him answer.
Yes.
Yes.
My lord, page 109, my lord, in this. The Fanshawe Education Institution has a minimum total enrollment of 25 students in class 10.
109.
Yes, 109.
Hmm. 109. Yes.
Yes, ma'am.
Total enrollment 25.
Yes, 25 students in
Whether the
class
word
10
appeared is there or not.
appeared.
No.
My lord, 3.5, it is only stated in an enrollment.
Enrollment.
Yes.
And in the impugn order, it is stated that appeared.
Yeah.
Appeared.
Yes.
So can it be said that the contender has duly understood the provision and thereafter passed the impugn order?
I have to take instruction regarding them, my lord.
Your lordship already.
Okay, at 2 p.m.
No, my lord, at 2 p.m.
Your already meeting was held. The report has been submitted in view of the state level scrutiny committee meeting. They have submitted this order, confusing the two terms, your lordship, annexing the copy of the order. Already the meeting was held, state level scrutiny committee, in view of the Honorable High Court's order. And they said that they had complied the order. However, your lordship, that was not at all being complied.
No, that's
Yes.
that's why let
Yes.
him obtain instruction.
Yes.
We'll take it up at 2 o'clock.
Yes.
39.
May please. Before I started, it was listed, lordship, this contempt matter, lordship. Appeal was dismissed. That matter, lordship.
Now we have taken steps for compliance, my lord.
Process has been started, lordship. It will come up. Process has been started.
Department will start the process
Yes,
of
Malad.
payment.
Yes, Malad.
When?
Now, Malad, we have to place the case of the prisoner before the SLC, Malad, state level committee, Malad. So it is headed by the chief secretary, Malad. So now we have to place the file. Today we will place the file before the personal department, then they will place it before the SLC, Malad. So Malad may fix it after 3 weeks, Malad.
No, not 3 weeks. It will
Because
take more time.
in any case, Malad, it will take some time, Malad, because once it is recommended by the SLC, then it will go to the finance department. So it will take some time, Malad. That is why I'm saying that 3 weeks.
Lordship, before filing the appeal, 1 year they have done nothing, Lordship. After 1 year, they have filed the appeal, Lordship. Then appeal was dismissed. Now they start the process.
That we're not disputing that, Malad. But now they have placed this before the chief secretary.
Okay, let it
It
be
will
after
be
3
2 weeks, Lordship.
We'll fix it.
Yes.
After 3 weeks, let them complete the process if they have started it.
Yes.
Heard Mr.
You are.
Ahmed, learned computer petitioner. Then also heard Mr. Katunier for contempt nurse. The Katunier has produced a letter dated 30/4/2024 of the Secretary to the Government of Assam Department of School Education. Then advises court that the respondent authorities have already started the process of payment of salaries to the appointees. And Mr. Katuni press for listing the matter after 3 weeks. Peer is accordingly allowed to list the matter on 28 May. The letter produced to the court shall be part of the record.
Item 40.
My lord, as per office note, my lord, service is completed. So far as
Service
number
completed.
6 is concerned. Come for admission, my lord, next week.
Heard Mr. Dr. Learned Security, Learned Counsel for the petition. According to office note dated 1/4/2025, Mr. Security submits that service has already been completed. As such, the matter may be listed for admission hearing. Accordingly, it is provided that the shall list the matter for admission hearing on after 2 weeks. After 2 weeks. Mr. Sisti, you are for respondent. So Sisti for respondent in Secondary Education Department. Number 1, 3, and 5. And for Finance Department, nobody. And Madam, you are for? Respondent number 4. Respondent number 4. List the matter after 2 weeks.
My lord, today we have filed an additional affidavit regarding the superannuation of the petitioner, my lord. That may be kept in record. He is already retired.
When did you file?
Today only.
Today.
Yes.
Mr. Secretary further submits that he has filed an additional affidavit, bringing on record the fact that the petitioner has already superannuated.
Yes, ma'am.
Superannuated. This is a let's just say the affidavit on record on next day.
All right.
41.
As per Kazima Court order, service is complete.
Service complete.
Service is complete.
We'll fix it for admission.
Heard Mr.
M. Gogol.
M.
M. Gogol.
M. Gogoi, learned counsel for the petitioner. Learned counsel for the petitioner and Mr.
I bought a ruler.
I-454 for respondent number.
Respondent number 3, 4, and 5.
3, 4, and 5, and
Chaos for respondent number 2.
K-Das for respondent number 2. Any other respondents?
Respondent number 6, lawsuit service is complete.
Service complete.
17.
None appears for the respondent number 6. So, service deemed to have been completed in view of the order of Lordship Court dated 17/3/2025. Mr. Upamunya for? Respondent number 1. Respondent number 1. Since service has already been completed, the matter will be listed for admission hearing on next day. List after 2 weeks.
Also, may fix a date, any date.
It's 24 matter. In usual course, it will come.
42. Look, on 6/11, notices were issued. And the department council appears for respond number 1 to 5. We were directed to take steps on respond number 6. We had taken steps, my lord, on the last occasion on 13/3/2025, as per the Lavazima Court
Have it
order.
completed?
Yes, my lord.
Yes, for elementary education department. Hard, sir, normal learned council for
The petitioner, my lord. Petitioner.
Mr. Kokon for respondent number
1 to 5.
1 to 5.
1 to 5.
So Kokon, you were perhaps not aware of for how many respondents you were appearing.
My lord, I'm not in this matter actually. It was Mr. P.N. Sharma's allotment. I'm hearing on his behalf.
So learned appearing on behalf of itself, elementary education department. So Sarna learned council for the petitioner referring to order dated 13/2025 passed by the Lavazima Court submits that service has already been completed and as such the matter may be listed for admission hearing. Accordingly, it is provided that this is the matter after 2 weeks for admission hearing.
My lord, there's an interim protection in our favor.
Pardon?
There's an interim protection in my favor, my lord.
Interim order pass RDS contact.
Yes, I'm grateful. my lord.
May I please, your lordship? Lord, basically the departmental proceeding as well as the suspension order is under challenge, my lord. We are praying, my lord, that as the period of, my lord, limitation, which is up to 90 days, my lord, is already over. So, my lord, that suspension cannot.
When he was suspended?
My lord, he was suspended on, my lord, 4/10/2024, my lord. My lord, may be pleased to find is at page
4/10/2024.
My lord.
Yes.
Thereafter, my lord, though the departmental proceeding had been initiated, my lord.
When?
My lord, the charge memo. No, my lord, before the suspension, my lord, what they have done, they have issued the charge memo before the suspension, my lord. My lord may be pleased to find the suspension, the charge memo is at page 82, issued on, my lord, 22/12/2023, my lord. And thereafter, my lord, I had been placed under suspension on, my lord, which I have brought into my lordship's kind notice, my lord, is on 4/10/2024, my lord. Now, my lord, as per my lordship is well aware, my lord, regarding that Ajay Kumar Chaudhary judgment, my lord, in such a situation, my lord, they are required to extend the validity of the suspension period, my lord, if it is beyond 90 days with a reasonable order, my lord, by reviewing the same suspension order, my lord. But till date, as per instruction which I have received from my client, my lord, it has not yet been reviewed. So therefore, my lord, it cannot continue at this moment, my lord.
Here, today it's come for orders, my lord. So, my lord, may fix it on admission, my lord. In the meantime, I will file an affidavit, my lord.
My lord, on the last occasion, my respected friend, Mr. B. Gogoi, submitted, my lord, if I am not wrong, my lord, that there is a office memorandum, he says that under such a situation, that suspension will remain in force, my lord. Now, that office memorandum, I do not have the access, my lord. If my,
That instruction is awaited, man.
no, it was syllabally office memorandum. Achha. Then, my lord, as per the, my lord, law governed by the Honorable Apex Court, my lord,
Yes,
suspension
well,
will go.
there is a notification issued by the government, my lord, regarding
My lord.
suspension part. In case of, my lord, where, my lord, the succeed has been submitted, the review is to be done within a period of 6 months or 3 months. There is a.
No, here the situation is quite different.
Different.
Before suspension, search memo was furnished to him on 22/12/2023.
my lord. So thereafter, my learned friend left to say when is the review was conducted or not.
No, review has not been conducted, my lord.
No, you will have the proper instruction. That is the averment of the petitioner.
So my lord, give me 2 weeks time. I'll file an affidavit. My lord,
No, Mr. Attorney,
Yes, my lord.
you only obtain instruction whether review was conducted or not.
Yes, my lord. That I can open, my lord.
Whether this
2 p.m. also he
order
can
is
do it.
No, my lord, 2
executed.
p.m. I cannot, my lord. Because I'll not be available at 2 p.m., my lord.
Pardon?
No, my lord, my prayer is that, my lord, it
2
can be
PM
by
I-
telephone also, because, my lord, this man is suspension from 6 months, my lord, and facing even the DP has also not been culminated. And the DP has also been initiated in violation of my lordship's order, my lord. I am not going through those on merit, my lord, that can be heard later on after the affidavit also. But, my lord, the man who is under suspension in violation of the Honorable Apex Court order, my lord, there is a series of judgments, my lord, that basing on Ajay Kumar Chaudhary's, my lord, suspension has been interfered with, my lord. And I am very sure, my lord, that the review has not been done because the petitioner has visited the office of the department day before yesterday also. That instruction I have sought from him, my lord. No review has been done. My respected friend can take instruction, my lord. I do not have any objection, but a short date may kindly be given, my lord.
On 9th, my lord.
Why not today?
Today, my lord, I will not be available. I
Aरे
have
कोंडा तो থাকিব
I have some emergency, my lord, medical emergency, my lord, I have to go, my lord.
Then Monday?
Lord, can it be on Tuesday, my lord? Monday, I have
Tuesday.
my lord.
Tuesday, I know.
Okay. Pardon, sir, Air Munia, learned counsel for the application. Mr. Attorney for respondents in secondary education or elementary education?
Elementary education, my lord.
Elementary education department and Mr. P. Gogoi for SCRT. SCRT. Mr. Attorney learned counsel for the respondent in elementary education department submits that he may be granted some time to obtain instruction as to whether after suspension of the petitioner on 4/10/2024, review was conducted by the respondent authority or not. There is accordingly allowed, is the matter on Tuesday at 2 p.m.
Mal. Obliged, file your
For respondent.
Tuesday. 2 p.m.
45.
Obliged.
My lord.
Yes.
My lord, in this case, we have filed one IA. I have checked it whether no formal notice has been sent. So at this stage, my lord, my prayer is that notice may go to them and they can file on the IA.
IA is for?
IA is for, my lord, provisional affiliation or temporary affiliation. That is, there is provision that also I have.
Mr. Gogoi?
Let the notice go, madam. And for the Assam University. Copy. Sorry, sir.
You are for?
Respondent number 2, sir.
Respondent
It is
number
the
2.
respondent number 2 who will have to give the my lord provisional registration. So these are necessary party.
That's correct, my lord. And if the notice goes, I will again file, give them notice, my lord.
Copy may be served to him.
My lord.
One direction.
Mr. Buragoi, pardon, say copy to him.
Yes.
Pardon, sir, Mr. Buragoi, learned senior counsel assisted by learned counsel for the petition. Sir, B. Gogoi for respondent
For 3
number
and
1.
4, my lord. No, 1 is Union of India.
Respondent number 2.
I appear for my lord 3 and 4.
3 and 4.
One.
And Mr. Gogoi for
I'm for 2.
respondent number 2.
Yes.
Respondent number 2.
It will to know. What people did it? It will know.
Only thing, my lord, there is the issue of maintainability of repetition as on date, my lord. That, my lord, lordship had said on the next date, my lord.
And your lordship may fix it after 2 weeks or 1 week as your convenience.
This
The whole case
interpretive
is
application
otherwise,
is
my lord,
preferred
ready.
by the applicants for issuing direction to the respondent number 2. The academic register Assam Science and Technology University to run temporary provisional affiliation as interim relief to the petitioner college, that is AK College of Pharmacy, Dental and Medical Science, Nagaon. Let notice be issued to the respondents, returnable on
Other respondents, they have got notice, my lord.
One.
If we give him, then the whole notice will be complete as a. Is it so?
no, whether notice was issued earlier in this IA.
My lord.
No, it's for the first time it is. For the first time. Let it be after 4 weeks.
Not for.
No, some orders are there, but notice has not been issued.
Yes, your lordship, issue notice will take
Notice to the respondents are returnable on
2 weeks, my lord. Not
after
more.
2 weeks. Okay, returnable after 2 weeks. However, no formal notice is required to be issued since
No, respondent one is union, madam. Nobody is appearing. It is the Ministry of Health and Family Welfare. Pharmacy Council, yes.
Pharmacy council. Pharmacy council.
no, not Union of India, Pharmacy Council of India.
Yes, Pharmacy
yes.
Council. In that case, my lord, it will have to be served by registered post. There is no
Yes,
standing.
Punba, any case? Good, good.
You have to take step upon respondent number 1. Then
Yes.
issue notice to the respondents, returnable in whether 2 weeks.
It
2
won't
weeks will.
suffice. No, it won't suffice, madam. Let it be after 4 weeks.
No,
And
my lord.
in the mean,
See, my lord,
my
my-
humble submission will be, my lord, so far as the main case is concerned, they have filed on IA, I will file my objection. But the matter has become infractor. There is a policy of the government, my lord. Now this respondent number 2 cannot issue any such registration. In this regard, my lord, same writ petitioner, 4 writ petition has been dismissed. I will place everything on the next statement.
But I have some argument.
In fact, this
to
was
place with your
placed, my lord,
lordship
this
on that
series was
point.
before this honorable court, my lord, while lordship was sitting in court number 10, in that part, my lord. The lordship had kept it for parted for a time being, but my lord, because of change of bench, it was released. And subsequently in court number 17, 4 writ petitions of the present writ petitioner has been dismissed. This was got left out because some time was sought for by the senior counsel for having instructions. from the-
Okay, you file your affidavit.
I will file my affidavit, my lord. It has become infractor, my lord. The policy of the government is saying, asked to cannot give any
We'll
registration.
say you file your affidavit.
My lord.
Like, okay. Step upon respondent number 1 be taken by registered post with KD and also by usual process within 2 working days from today. However, no formal notice is required to be issued to the respondent number 2, 3, and 4.
4 and 4.
As they are represented by their engaged counsel, by standing counsel. However, extra requisite copy of the petition be furnished to them during the course of the day with the matter after 2 weeks to start your notice.
No.
46.
But here, notice upon respondent number 4 has been completed. I filed an affidavit, Mal. Trustee service has been. Affidavit filed on 25th, Mal, but most of it is before lordship.
Part Mr. Goswami, learned counsel for the petitioner, and Madam Sahari for respondent number
123.
123. Order dated 1/4/2025 of the Laws in Court indicates that service upon respondent number 4 has already been completed. Since service has already been completed, this shall list the matter for admission hearing in usual course.
Highly
Writing items, item number 3 for admission.
Item number 3, Lordship, I have been informed by the secretary that a 1 week time is required. Already director has sent a proposal to the government. It is now government 1 week to issue the sanction letter, Lordship. That
1 week to
what?
issue sanction.
Sanction letter. Lordship. Yes. The finance has given approval. The actor has sent a proposal to the government, the secretary. Now it is in the secretary lordship. At a 1 week time lordship. You answering the council election lordship a little bit difficult. Lordship 1 week time can be given to issue the sanction order.
Let it be after 1 week. I will fix it.
Hardly see.
But everything
In
is
every
within the action
time,
lordship.
last occasion, he stated that 1 or 2 days is required. Now, after 10 days or 15 days, he came again, there that proposal has been sent to the
1 or 2
government.
days, I have said, I think to take instruction, actually. 1 or 2 days, lordship, I don't submit that it will be given. I think
Because of my lord,
No, this matter was listed on 10/4/2025.
10/4. Yes, lordship.
and my lord, finance department already accorded my lord
Sanction.
sanction,
No, approval is given.
approval given.
Now, thereafter, the director has given the proposal lordships. Now it is, now the only sanction letter has to be issued by the secretary lordship for release of that amount.
Sir, is there appeal learned product petitioner and subsidy for respondent number?
For a department lordships.
Respondent in elementary
Elementary.
education department and Mr. Soliha for finance department. So CC submits that finance department has already accorded approval. And now the director has sent one letter
To the government for sending the proposal.
for
And now it is sanctioned, as a letter will be issued within a week. Lordship.
Non-royal certificate has been required.
government, no, director has sent one letter to the government
Government lordship.
for
For release of that amount, 3 lakhs something. Lordship.
for release of the amount due to the petitioner and press for listing the matter after a week. Where allowed, press to list the matter on.
Yes.
Okay. 14th of May. 14th of May.
Coming items,
Yes, Parker.
coming items, 8 and 9.
Maybe, I'll see the last order, my lord. Last occasion, the elementary division development directed to obtain instruction, my lord. Miss S. Sutia was appearing. Elementary.
So it's for elementary education. So what instruction is available with you?
I have no instruction lordship, lordship I fixed. Next to lordship, some instruction. Today I have no instruction lordship. And it is shown, it is also a party.
It is already filed available. Now government.
Lordship,
Department
instruction is
taking.
awaited lordship, then 2 weeks. time.
No, next week, my lord.
Next week. I will not be there lordship. After 2 weeks lordship.
Third, Mr.
Sir Ahmed.
Sir Ahmed, learned counsel for the petitioner, and Sir P.N. Sarma, learned standing counsel for the respondent in elementary education department. And Madam, you for? Let's borrow learned counsel appearing on behalf of
BTC.
learned counsel for the BTC.
Yes, ma'am.
BTC. Mr. Sarma submits that though there was a direction for obtaining necessary instruction in the order dated 21/4/2025, yet instructions are still awaited and press for listing the matter after 2 weeks. However, 1 week time is granted to Mr. Sarma to obtain necessary instruction. List the matter after 1 week.
Date may be.
Coming item 12,
Date may be fixed, my lord.
Take it that.
Ullash, ma'am.
UPMS.
In this matter, some documents yet to be collected by the inspector of the school, and moreover, headmaster of the school has not given all the documents as because headmaster has already been reconstructing the file manual.
And moreover, petitioner has not delivered to some documents to the headmaster. As per my instruction, as per information given by the IS. My lord. And she already told me that GIS may be given within a week or 10 days.
And
They are preparing for the GIS payment, but rest of the plans
GPF,
of
etc. Ivella?
the, 1 week or 10 days, my lord. GIS, regarding the GIS.
No, other benefits.
Headmaster is constructing the file, my lord. Some documents is missing, my lord.
Okay, at 2 o'clock, let Mr. Patiri come.
Item 14, timing item. Timing 48.
Please, my lord.
Although the matter was fixed at 2 Lordship, today I have some difficulty. Can it be taken up next week, Lordship? One of the council will appear. Because on the last occasion also, there was another council who appeared and he was taking care, Lordship. So today some difficulty, Lordship. Can it be taken up next week, Lordship?
May it please, my lord. My lord may kindly peruse the last order where it is stated that it will be taken for final consideration today. And my lord, any council can stand for the department, my lord. There is no embargo as to that. My lord, the matter was heard at length on the last occasion. My lord, then my prayer would be
There
that
was another council, Mr. PK Bora.
from the same,
They are lost.
then my lord, my part may be heard today. It may be kept as part heard. I would like to do my part, my lord. Because my lord, every day is
Tuesday or Thursday.
my lord, for final consideration, it is fixed today.
Let it be on Tuesday.
Lordship.
My lord, then it may be kept as part heard because on the
Okay,
last
okay. Heard Mr.
PR Sarma.
Pierre Sharma, learned Board of Petitioner, and also heard Mr. Ian Sharma, learned representative also for the respondent elementary education department. Then, Madam, you are called?
Yes. Number 8.
Respondent number 8. Respondent number 8. Mr. Sharma submits that Mr. P. N. Sharma, learned representative counsel for the respondent saying elementary education department submits that today he has some difficulty in arguing the matter and press for listing the matter on next Tuesday. Here is allowed, let's list the matter on Tuesday.
My lord, matter may be kept as part heard.
Okay, as part heard.
Okay.
I am not there in this.
Okay. Any other?
Deeply obliged.
The inspector of school has not received all the documents.
Mm.
And moreover, headmaster also not received all the documents and he is constructing the file, my lord. So sometime is required, and the inspector of school already informed me that GIS may be given to him within a 1 week or 10 days.
I have already regularly contacted with the headmaster, my lord. He's not asked any, speaking any document, my lord.
The question is whether you have furnished all the documents to the headmaster.
As per my instruction, I furnish all the document, my lord.
Hmm.
And in the earlier occasion, my lord, the letter reflect that, my lord, it may be completed within 34, my lord.
Within?
304, my lord. That's why that was fixed today, my lord.
And here written, all the required papers, documents of the incumbent concerned could not be submitted correctly by the headmaster. However, after instructing the headmaster concerned to submit the papers correctly, initiative has been taken regarding granting pensionary benefits to the petitioner concerned. Hope this may be completed within 30 April 2025. So my lord, as per my my information, as I called the inspector of school today, She told me that she is not getting the all documents. So pensionary, so pensionary benefits, or pensionary documents, could not be prepared. For his releasing the benefits. So sometime maybe guaranteed, my lord.
Otherwise, my lord, personal appearance may be given, my
At
lord.
least 2 weeks, my lord.
Headmaster, my lord, as well as inspector of school, my lord. So my lord is 22.
Inspector has no fault, my lord. But headmaster, from the headmaster side, it is not coming. Documents are not coming.
Yeah, we are granting a 1 week time. Complete the process, otherwise, they have to appear. Or Mr. Pampiri learn a productivity. So Sorma learned admin council for the rest. The headmaster of the concerned school could not file the documents to the inspector of the school, or who is the pencil paper of the petitioner could not be finalized. Not be finalized. However, Mr. Sorma said the GIS amount of the petitioner could be paid within a period of 1 week.
1 week or 10
or 10 days from today. And accordingly, Mr. Sorma pays for granting him 10 days time. Here is allowed. In the event of failing to complete the process, the court will consider presence of the inspector of the school and the headmaster, personal appearance of the inspector of the school and the headmaster for the court on next time. This is the matter of public.
19,
10 days.
after 10 days. 16.
And then, my lord, sponsor election also, dear my lord.
No, 7, my lord.
Oblige. Timing item 14.
Dear my lord, inspect, here, Rukumar Sharma. Comment number 6.
Respondent 6.
Has already been appointed as a headmaster.
So the matter has been closed by the committee. So you have been, it is stated that you have been appointed as headmaster of the Gopinath Polytechnic Institute.
But Lordship, he is much junior to the petitioner, Lordship. The petitioner was appointed, joined his school in 1992, and the respondent number 6 has joined in 1996, Lordship. And he is most senior most person, petitioner is the most senior most person, Lordship, in this school. And he was interviewed and he was also recommended.
Mr. Sharma, whether you have filed your affidavit?
No, Lordship.
You have filed your affidavit? No.
And also without disposing the representation, how the respondent number 6 can be appointed?
But here not challenge the appointment in this victory. Already.
No, this.
That is not our Lordship.
Has already been appointed.
And the Lordship petitioner has retired from service last year, Lordship, April last year.
An appointment was made 12th August 2022.
Long back.
There was any grievances, they could have challenged that order.
Lordship, appeal has been filed in the year 2021 against the complaint filed by the respondent number 6. Should be here first, Lordship. Appointment was made in the year 2022, Lordship.
Mr. Sharma, you file affidavit. Will you say? Pardon, miss, your good name, please.
P. Soria.
P. Soria, learned of Court of Exam, and Mr. Q. Sharma, learned standing counsel for the education, secondary education department, and Mr. Sharma, Mr. U.
J. Das, Lordship.
J. Das,
Respondent number 4, my lord.
learned counsel for the respondent number 4, and Madam Fukon, you are here. In the course of deliberation, Ms. Sohoria has referred to a representation dated
Date is not there, Lordship. December 2021.
December 2021, at annexure number 15. Address to the committee. Address to the chairman, Committee on Petition, Assam Legislative Assembly, Dispur, Guwahati. And submits that the said representation is yet to be disposed of by the said committee. But Mr. Das, learned counsel appearing on behalf of the said committee, has produced written instruction before this court. And submits that the petition representation filed by the petitioner has been closed. In the meeting held on 27/9/2022. As one. Rup Kumar Sharma has already been appointed as headmaster in the Gopinath Polytechnic Institution, Nalbari, by letter dated 12th of August 2020. So Sharma, learned counsel for the respondent authority submits that he may be granted some time to file affidavit in opposition thereof. Let's submit the matter after 1 week. No. For indefinite period, we cannot grant you time. Or let it be after 2 weeks. For a fixed date.
2 weeks, 21st. For bail hearings, 27 and 28, matters.
Lordship, in this case, Mr. S. Das will appear, Lordship. He is on left.
I am not going to.
He was there, but
Next.
38.
In this matter, secondary education department has obtained the data from the SEBA. And as per SEBA report, 22 students appeared, and as there is a cancer school and nobody is counted how much enrollment is there on the master all these things might not do. As per SEBA's report, education department
No, you tell me whether this order was passed in accordance with law or not.
Here, my lord, as per SEBA, my lord, I know more about 35% enrollment.
No. The question is whether they have passed the order in accordance with law or not. You tell me. Whether enrollment and appeared
Yes, madam.
are same thing.
As per I have received the information from the department that enrollment is counted as the department, as the SEBA has received the information from the school concern. And according to their school, 22 persons appeared, my lord. So, and
Then
SEBA provide the
if
instruction.
that is your stand, let the director remain present in the court.
Here, my lord, in the.
If
page
that
51,
is
my
your
lord.
interpretation,
My
then
lord,
okay.
that's the page 51, my lord.
Pardon?
Page 51, my lord. Enrollment of the student in class 10 for the year 2015. Here, my lord, 23 numbers of student Pinky Das last. So, and here registration number year 13. But rest are the repeaters, my lord. 24 to 35 is repeaters. All are repeaters, my lord. So, my lord, as per report of SEBA, that order has been passed, ma'am. And regarding the enrollment. it is
So
32
repeaters means those who have appeared in the examination, right?
Repeaters, my lord, these repeaters are enrolled in earlier years, in previous years. Not that year. It is in the registration number, it is in the last, it is
No.
12,
No, you come to page number this 50,
51.
50, annexure 10.
50. Yes, my lord, and except 10, my lord.
What is the enrollment number in
Enrollment
that
number is
particular year?
35 is written, ma'am.
Pardon?
35 is written.
Then
My lord, sometime may be granted, so I will take the fresh instruction regarding that.
no, let the director come. Let her explain
Hello,
what
one
she has
second.
considered.
One chance may be given to clarify their position, my lord.
Okay. Monday. Heard Mr. Sarma, learned counsel, P. Sarma, learned counsel for the petitioner. And also heard Mr. U. Sarma, learned standing counsel for the contempt order. Director in Elementary Education Department. Secondary Education Department. On the earlier occasion, Mr. Sarma has produced the speaking or the order dated order dated 18. What is the date?
18/4/24.
18/4/2024. And submits that the order of this court dated 5/1/2024 has been complied with. But Mr. P. Sharma, learned counsel for the petitioner, filed an additional affidavit stating that while passing the order dated 18/4/2024, the respondent authorities, the contender has taken into account the number of students appeared in the SSLC examination in the year 2015, which is not in accordance with the section 3 within bracket 5, Roman 5 of the Assam Education within bracket provincialization of services and reorganization of services of teachers and Reorganization of Educational Institutions Act 2017 as amended in 18. There should be minimum enrollment of 25 students in class 10. And as the said requirement has not been fulfilled by the institution of the petitioner, the same could not be provincialized. But Mr. Sharma submits that in the particular year, that is 2015, the enrollment in the school, petitioner school, was 35. And students appeared in the examination was 22. But the section 3, 5 of the Assam of the Act of 2017 contemplated the number of enrollment, not the number of students appeared in the examination. And as such, the order dated 18/4/2024 is not in fact compliance of the order of this court dated 5/1/2024 in WPC number 7311 of 2023. That is Mr. Sharma, learned standing counsel for the respondent authority, submits that he may be granted some time to obtain necessary inspection. There is accordingly allowed. The annexure number 10 at page number 50 of the additional affidavit filed by the petitioner be furnished to Mr. Sharma, learned standing counsel for the contempt note, so as to enable him to obtain inspection whether at the time of passing the order dated 18/4/2024, the respondent contempt note has taken note of the number of students, about the number of enrollment in the year 2015 or not. List on Monday.
On that day, my lord, in view of the past in my lord, criminal appeal number 3865 of 2023, my lord, Ramkishore Arora versus Directorate of Enforcement, my lord. In that case, my lord, I pointed out to your lordship that in view of the Concord Bonson's judgment on which my lord, anything, my lord, grounds of errors in writing, which was my lord, that point is my lord declared to be as my lord prospective by the judgment, by the present judgment, my lord. Your lordship may kindly peruse paragraph 23. As discernible from the judgment in Pankaj Bassal case, also noticing the inconsistent practice being followed by the officers arresting the persons under section 19 PMLA, directed to furnish the grounds of arrest in writing as a matter of course henceforth. This is important, my lord. Meaning thereby, from the date of the pronouncement of the judgment, the very use of the word henceforth implied that the said requirement of furnishing ground of arrest in writing to the arrested person as soon as after his arrest was not mandatory or obligatory till the date of the said judgment. So, my lord, as because Pankaj Bansal judgment passed on 4/10/23, so my lord, in all the cases, my lord, where arrest is made prior to that, my lord, then in that case, my lord, furnishing written grounds of arrest in writing is not at all applicable, my lord.
No, the question is whether Mr. Das has relied upon that judgment, Pankaj Bansal.
Because my lord, Vihan Kumar relies on Pankaj Bansal, my lord.
Ah.
So this will also be of importance.
My lord, regarding, but Bihan Kumar also relied to Pankaj Bansal, it is okay. But my lord, in that Bihan Kumar's case, the issue regarding the issue regarding whether it is prospective or retrospective, that issue
That
was
has not
not,
been
not
discussed.
discussed, my lord. But while the Belayam Trivedi, my lord, this judgment already discussed and held that, my lord, that Pankaj Bansal case is prospective, then this case is applicable, my lord. Because that issue was never raised or discussed in the Bihan Kumar judgment, my lord. So Pankaj Bansal decided on 4/10/23, my lord. 3/10/23. Here in this case, arrested, my lord, in the month of September 23, my lord. So in that case, my lord, providing written information of the grounds of arrest is not at all applicable here. And my lord, argument was also, my lord, accepted by the coordinate bench of this honorable court in a case, my lord. Although in that case, my lord, my case arrest was, my lord, after Pankaj Bansal, although that point was not, my lord, my case was, my lord, ultimately bail granted. Although, my lord, that point was, my lord, also discussed by the coordinate bench of the honorable court and accepted. Your lordship may kindly peruse paragraph, my lord.
Yes, Mr. Das.
Look, can this matter be taken up next week, my lord? I would also like to go through the judgments, my lord.
Next week.
Yes, my lord. Because, my lord, in Pankaj Bansal, the arrest was made effect on the month of June 2023, which was deemed to be illegal on the basis of the law of the land. At that point of time, my lord, there was no other judgment, and the Supreme Court relied on the Constitution of India to say that these grounds of arrest should be furnished in writing on June 2023. So considering that this matter is of the month of September 2023, perhaps, my lord, this benefit can also be given because it is after the, my lord, Pankaj Bansal's arrest date, my lord, date of arrest in Pankaj Bansal's judgment. My lord, I'll go through the judgments, my lord. Let this matter come up next week, my lord.
That is also clarified and decided by the Belayam Trivedi's judgment because it is specifically stated after this judgment is effective only after 4/10/23. Ram Kishore case.
Okay. To go through the judgment.
Yes, my lord.
Our Mr. Esdras, learned counsel for the petitioner, and Mr. Portakur and Mr. Portasor. Okay. P. Portakur for the state respondent. Mr. Das, learned counsel for the petitioner, submits that since Mr. Portakur has relied upon the decision of Honorable Supreme Court in the case of Ramkishore Arora versus Directorate of Enforcement, reported in 2023 0 Supreme SC 1253 to contend that the effect of judgment of Honorable Supreme Court in Pankaj Bansal versus Union of India is Union of India
Pankaj Bansal versus.
What is the citation?
Pankaj Bansal, my lord.
Yes.
2024 7 SCC 57
2024 7 SCC
576, my lord.
576. Will be prospective in nature. Be prospective in nature. And as such, the present petitioners are not entitled to the benefit of the decision in Bihan Kumar versus state of Haryana and another reported in 2025 SCC online essay 269. 269. Relied upon the decision of Pankaj Bansal within bracket Supra. And he may be granted some time to go through both the decision and release the matter next week. Here is accordingly allowed. Let's submit the matter of COVID.
16th May.
16th May.
Highly obvious, no?
Timing items 29:30, Pattern matter.
This petition is directed against an order passed by the Learned Executing Court, rejecting my prayer under section 47, the Code of Civil Procedure. But was it happened in this case? I'll briefly state the facts. The decree was obtained by the respondent, who was the plaintiff in the suit. Decree was obtained fraudulently and collusively. That was my whole case, Lordship. Lordship will find that the whole claim of the respondent was based on two documents, namely one deed of agreement entered into by the respondent and one Ambalal properties. And whereby it was, the Ambalan property was described as the company, as a company in the agreement. But subsequently, the suit was filed in the name of the Ambalal properties as partnership. So two things cannot go together. Either there will be a company or there will be a partnership firm. And the suit was filed by the respondent on Ambalal property as partnership firm. That means it was within the knowledge of the respondent that it was neither a company nor a partnership firm.
You first come to the this impugn order.
I'll come to that. Well, otherwise, unless I explain briefly, I will state the facts. These two documents, Lordship will kindly, I'll first take your Lordship to those documents. First, I'll take your Lordship to the order, initial order, on the basis of which decree was passed. Page 74. First, Lordship will
Page
64. Come to that order. Annex of 5. Page CRP 94, 2024. Page 64. Now, so I kindly read the order. Plaintiff is present. Defendant has not appeared. Summons were issued by registered post on 25/11/2005, but edit cards have not been received back. Learned Counsel for the plaintiff has submitted that as per provision of Order 37, Rule 3(2), summons may be deemed to be served upon the defendant. This is a suit for summary trial. Therefore, summons sent by post in the address of the defendant given in the agreement are deemed to be served as per the provision of Order 37, Rule 3(2) of CPC. In a summary trial, the defendant is to appear within 10 days as per the provision of Order 37, Rule 2(3), and they are to disclose their defense, if any, but the defendant has failed to do so, and hence, I am going to dispose of this suit. The case in brief is that the defendant took loan of rupees 42 lakhs
from the plaintiff by executing an agreement on 24/9/2005 at the rate of interest of 18% per annum and to return the money within 3 months. Defendant issued check for repayment of loan which was to be returned unpaid, hence the suit. In absence of any debatable evidence from the defendant, the plaintiff is entitled to a decree as paid for. This should be decree ex parte for an amount of so and so. So Lordship will say this is the order. Without executing any document, without considering any document, even if this document is referred, that was also not exhibited in the suit, Lordship. And thereby an order came to be passed. And on the date when the order was passed, well, it was fixed for only service report, not for hearing. It was only fixed for service report, and the decree was passed. And Lordship will see there are two defendants. Lordship will kindly come to the plaint.
39.
Please 39.
Yes.
39. Okay. 39.
39. Yes.
Lordship will come to the page, yes, 39 to 54. Now, plaint 39, annexure 2. Lordship will see Monesti is the respondent here. And the defendant number 1 is Dulu Tea Company. Dulu Tea Company is the petitioner here. And respondent number 2 is the Ambalal Properties and Investment. The defendant number 1 is a public limited company incorporated under the Companies Act. That means the defendant number 1. And the defendant number 2 is a partnership firm registered under the Indian Partnership Act 1932. Both are having resident, their registered offices at so and so, so and so, so and so. So these are the two defendants, Lordship. And here the defendant number 2 was described as a partnership firm. Now Lordship will kindly come to the document. That is declaration is at page 55. The documents on the basis of which Lordship the decree was passed. Lordship will kindly see. These documents were concealed by them. It was never placed before the court. It was not executed. Page 55. Lordship. First, Lordship will take up the declaration. Both are of same date, 24/9/2003. I, Hasmukh Patel, son of late Rambhai Patel, the managing director of Dulu Tea Company, a company duly registered under the Companies Act 1956, which is registered office at so and so, so and so, so and so, village so and so, so and so, do hereby declare that the aforesaid company has taken a loan of 40 lakhs as a loan repayable with interest at the rate of 18% from Monesti Company, a proprietorship concern, which is office. Proprietorship concern means he is the plaintiff, which is office at so and so, MS Road, Sri so and so, son of so and so. The said loan amount is repayable within 3 months from the date of this declaration. I further declare that I have been authorized by the board's directors by the resolution dated. It's a blank clause. There is no resolution. So admittedly, resolution is required for the company. Without resolution, the managing director or director or whoever he is, he cannot obtain loan. I'll come to that provision of the company's Lordship. To receive the said loan amount from the aforesaid company and to issue post-dated checks, so and so, so and so, so. So these things were done without the resolution of the company. Admittedly, resolution of the company is required under section 292 of the Companies Act. And here, Lordship will see there is no resolution of the company. It is kept blank. To obtain a decree, they will have to produce the resolution of the company before the court. And they have concealed this document. They did not exhibit this document before the honorable court. So the decree was obtained by misrepresentation of fact, So thereby it is a fraud. I'm placing the judgments also. Fraudulently, they have obtained the decree. And then lawsuit will find next agreement. Annex 4.
Annex 4.
Annex 4. Page 58. I am placing all this because of the fact that in the impugn order, these documents were not at all considered. That is why I am placing the facts. Annex 4, page 58.
Page number?
58. Highway. On Ambalal Properties and Investment, a company duly registered under the Companies Act. Now here in these two documents, my lord, the Ambalal Properties was described as company. Whereas in the plain, they have themselves described the Ambalal property as partnership firm. That means it was within their knowledge that it is neither a company nor a partnership firm. Because in order to be a company, it has to be registered under the Companies Act. There was no material before the court to hold that they are the company. And this apparent, lordship. By reading these two documents and the plain, it is apparent that it is not a company. Actually, it is a registered firm, and decree was passed against the registered firm. If the company has taken a loan, then how the decree can be passed against the registered firm in the same name? Actually, this is the handiwork of the of one particular person. One Harshat R. Patel, who claimed to be the director of Ambalal, who claimed to be the director of managing director of Dulu, both the companies. He becomes a director by discussion, and that Hasmukh Patel, by doing all these things, he wanted to siphon up the money belonging to the petitioner company, because the company's money, it is not his personal property, let's say. It belongs to all the shareholders. Therefore, there is a provision that if you obtain loan or if you repay loan, then you have to obtain one resolution as per section 292 of the Companies Act. Without resolution, he may be a director or he may be a managing director. They do not have any individual power to obtain loan or to repay the loan. They are saying that they have issued, he has issued check. He has issued check in his personal capacity. If any decree is passed, it should be passed against that Ambalal property, personal property of the smoke. Lordship will kindly say again, the position will be clear if your lordship kindly go to page 60.
16.
60. Next month, same document.
Yes.
Now, Mrs. Monesty Company is the respondent. Propositive concern represented by his proprietor Binod Kumar Bengani, son of so and so, Fancy Bazaar. Any after call second party shall, unless excluded by or repugnant to the context, be deemed to include his legal heirs, successors, representatives, and assigns of the other part. Whereas the sister concern of the first party, namely Dulu Tea Company, my lord, Dulu Tea Company is not a party in this particular agreement. Also, you kindly note. Only mentioning the name of Dulu Tea Company as a sister concern, Harshat Patel, he obtained the loan, he received the loan, and that is, let's again come to the after that, whereas the sister concern of the first party, namely Dulu Tea Company Limited, has taken a loan of 40 lakhs as a loan from the second party, but since the aforesaid sister concern of the first party has no immovable property in its own name at Guwahati, to mortgage the same to the second party as a security towards repayment of aforesaid loan amount, the first party hereby agrees to mortgage the land as described in the schedule in favor of second party towards repayment of the aforesaid loan amount to the second party. And the second party has also agreed to accept the mortgage of scheduled land by the first party in favor of second party on terms and conditions of the, as mentioned below. Now, this deed agreement witnessed that the second party has paid to the aforesaid sister concern. Paid to sister concern. He is not a party. Of the first party, a sum of rupees 40 lakhs by demand of, let's say again, can see. There is no demand number. That means that amount was never transferred to Deluti company. The number is, draft number is, there is no draft number. For the first time I was seeing that on the basis of these two documents, decree was passed. Without draft number, without resolution, that means no money was transferred to the petitioner, Dulugu Tea Company. Only their names are only mentioned. Supposing that there is an agreement between me and my colleague, there is an agreement, and he is not a party, but his name is mentioned, stating that he will repay the amount. He is not a party to the agreement. The agreement is between us. Merely by making a party, the Mr. God, allowing him to obtain the amount. It cannot be a contract between the petitioner and the respondent. That's it. It cannot be deemed to be a contract because the petitioner is a third party here. So the respondent and that Ambalal property, they cannot bind me to repay the amount. That is what actually just happened here. Now, Lordship will kindly skip to the other parts. 5, clause 4 and 5. That the first party has also declared that he is the absolute owner of the plot of land measuring 4 bighas, 4 quarters, 7 lasses, covered by DAG number 584 under KP Pata number 172 of Village Maidan, Guwahati, fully described in the schedule. The aforesaid land was purchased by the first party from the vendors by registered sale deed number so and so. That the first party has handed over the original sale deed of the aforesaid land, including latest revenue receipt and copy of the Jamamni to second party as a security towards repayment of the aforesaid loan amount by the aforesaid sister concern of the first party, and the first party binds itself not to sell the said land or otherwise transfer the said land by any mode or modes to any person or persons until the aforesaid loan amount is cleared by aforesaid sister concern. Again, when the sister concern was not a party, every time their names are mentioned here, so that the money belonging to the company can be siphoned off. Now, Lordship again will come back to the order passed by the at page 64. Passed by the trial court. Now, here the decree was passed against defendant. Actually, there are 2 defendants in the suit, but here defendant numbers are not mentioned. Lordship, for example, Lordship will kindly come to first line. Plaintiff is present, defendant has not approved. Who is defendant? Appeared. Who is defendant? And again, in the second line, it is suit for summons, therefore someone sent by post in the address of defendant. Who is defendant? In a summary trial, defendant.
No, this is not the impugn order.
No, this is not. No, these facts were not at all considered. That is why I'm asking.
The decree was passed rightly or wrongly. That has not been assailed.
No,
that was assailed, my lord.
no,
Assailed.
please.
Yes, they.
No, let him not disturb me.
I'm just
Madam.
correcting.
God, please.
Let me complete. My case was that in the objection, Lordship, this decree was obtained fraudulently and collusively with the Ambalal property. Also, R. Patel. That was my case. So the allegation was fraud and collusion, and it can be gone into Lordship knows. It can be gone into at any stage of the
Mm.
proceeding or subsequent proceeding or in any collateral proceeding.
Mm.
Because he may say that no, in this execution petition, execution proceeding, these issues cannot be raised. They may say that is why I'm listening. So I'll take a little time. That's it. So, do I saying that this DP was obtained fraudulently? Whether this issue can be raised in execution proceeding? That from that angle I am pressing. Yes, Lordship. Then, Lordship,
Address of the defendant in the agreement. Okay, our address are not there in the agreement.
they are again, last time, Lordship, he submitted that on that pretext, he got my stay order vacated on the pretext that we are residing in the same building. How can I decide? These are, one is company, one is partnership firm. How they can decide in the same building? That I will come later. Now, Lordship, on the basis of the judgment and decree, Lordship, the decree was sought to be executed against the against Harshat R. Patel, properties of Harshat R. Patel, Lordship. So they sought to execute the decree against the personal property of Harshat R. Patel, Lordship. And till 2016, Lordship, they pursued that matter. Page 84, Lordship, Annexure 8. Lordship, can you see how the matter was dealt with and how the learned executive court has disposed of the matter? These things were not at all considered. That is why I am pressing. Annexure 8, page 84.
Annexure 8.
Yes. Although decree was passed in the year 2005, they continued with the execution till 2016, Lordship, against the defendant number 2, Ambalal. That is represented by Harshat R. Patel. Lordship, kindly and order dated 8/1/2016. Lordship. Case record put up today, as it was not put up on the fixed date, the decree holder is represented and through petition number so submitted that the concerned circle officer may be directed to execute the writ of attachment on the basis of the old DAG and patta number by comparing with the new DAG and patta number. That is their pair. Their pair. I have produced the order to so by which it was directed that circle officer concerned to produce new DAG and patta number of the concerned property. It was submitted that the concerned Mandal has failed to identify the concerned property for which writ of attachment was issued. Considering the materials before this court, at this stage, it is directed that the writ of attachment issued earlier will be executed after comparing of the old DAG, patta with the new DAG and patta number of the concerned property on the basis of land revenue record available at the office of the circle officer. So this was a very, very reasonable order, Lordship. They could have executed the decree against the defendant number 2, but they did not, and they did not take steps on the basis of the order passed by the honorable court. They did not take a step, but suddenly in the year 2022, Lordship, what they have done, one compensation amount was lying with the Deputy Commissioner Kasar for acquiring our land, and that amount was being deposited in the office of the DC, Kachar. And what they have done in the year 2022, they filed an application before the honorable court and filed order dated 18/5/2022 at page 85, Lordship. The honorable court attached the order, the amount by order dated at page 85A, operative portion also will find. The honorable court attached the order on 18/5/2022. Then, Manat, when the decree was sought to be executed, although there was a decree against defendant, without mentioning the name of the defendant, the decree was sought to be executed against the defendant number 1 in the suit and the present petitioner in the year 2022 lordship. So before that, the decree was not sought to be executed against the present petitioner. And now they are saying that they are delaying the matter, the decree of so and so, so and so. So there is a difference, lordship. They actually, they ought to have executed the decree against the defendant number 2. In the agreement also, clause 5 mentions that yes, in case non-payment of the amount, then decree will be executed against the personal property of Harshad Patel. So as per that, they proceeded against him, but they did not take any steps despite the order passed by the court. Only in the year 18/5/2022, the decree was sought to be executed against the particular this petitioner, lordship, who was the defendant number 1 in the case. Then, having come to know about that, after that, after attachment, then we obtained the copies of those documents, those 2 documents from the court, on the basis of what the order was passed, because it was not executed in the suit. Then we came to know about those documents. Therefore, we will file an application under order section 47 of CPC before the Honorable Court. And that the petition was taken up for hearing by the learned the executing court. And thereafter, the impeachment order was passed. So in brief, that is then I'll come to the law when I read the impeachment judgment also. How the matter was dealt with. The although it was an executing proceeding lordship, it was stated like a suit. 7 issues were framed, and 1 witness was examined on our behalf. They did not examine any witness in the execution proceeding. And the issues also will find. And also I'll read the judgment. That will be better because flags are also mentioned. At page 198, start from 198. May I? Yeah. The petitioner's case revolves around a decree passed in 2003 for a recovery of 40 lakhs owned by Harshad Patel from decree holder. This was based on an agreement dated 24/9/2003. This was not examined. The petitioner argues that the money owned by Harshad Patel was in the name of Messrs. Duluti Company Ltd, referred to as judgment number 1, but judgment number 1 was not a party to the agreement. Instead, the agreement was signed by Ambaral Properties and Investment, which is claimed to be a company under the Companies Act 1956. However, no company is registered under the name. The petitioner also states that documents from another interested party indicate that the said firm is a Hindu undivided family of 2 brothers and Patel family. The petitioner argues that JD number 1 company was made a party to the loan by Hasmukh R. Patel and the decree holder in a malicious manner and in collision, as no one from JD number 1 signed the agreement with the decree holder. The petitioner asserts that there is no acknowledgement of any loan by JD number 1 in the entire record. It further alleges that the decree holder is a proprietorship firm, with Binod Kumar Bangani being a proprietor, and it is settled law that no decree can be passed in favor of the proprietorship firm. As the suit was filed in the name of Monesty Company, a sole proprietorship, the petitioner argues that it is not legally maintainable and hence the decree was passed is not executable against this present petition. The petitioner further contends that the plaintiff decree holder is not a registered firm under the Assam Money Lending Act, and the debt is not legally enforceable. Additionally, it is alleged that the loan transactions are ultra vires, as JD number 1 never completed the procedure formalities of passing a special resolution under section 293 of the Companies Act. Accordingly, petitioner prays for rejection of the execution application. The decree holder is objecting to the petition filed by the applicant JD number 1 under section 47 on the grounds that it is not maintainable. The decree holder claims that the applicant had previously filed Miss so-and-so, which the court rejected, and argues that JD number 1 is precluded from raising further objection to the current execution proceeding. The decree holder also accuses judge number 1 and its director of habitually filing various applications to obstruct or delay the execution of a lawful decree. Additionally, the decree holder brings up a summary money suit and a complaint case for dishonest check, both of which are still pending due to non-appearance of the judges. The decree holder denies most of the statements made in the petition and alleges that judge number 1 knowingly made false statements with malicious intent to avoid lawful liability. It is also stated that judge number 2 acted as a guarantor for loan taken by judge number 1, and the judge number 1 issued post-dated checks for loan repayment, which were subsequently dishonored, leading to the initiation of criminal proceeding. The loan transaction agreement is not fraudulent, and there is collision between Hasmukh R. Patel and loan of rupees so and so was initially for a period of 3 months, but the JD number 1 failed to make the payment. The decree holder took necessary steps for execution of decree, including attachment of sale land, but the JDs objected to these document attempts to delay the execution. The decree holder made the payment in good faith, and the property given as security could not be identified during the execution proceeding. The application made by the applicant is seen as having been filed with malicious intent to thwart or delay the execution of the lawful obtained decree by this court 15 years ago, and is liable to be dismissed with compensatory costs. So here, you will find that they did not raise any plea. They did not rebut the case of the petitioner that these two documents were obtained fraudulently and in collision of defendant number 2. There is no rebuttal statement, or when the witness for the petitioner was examined, he was also not cross-examined on that point, on those 2 vital points, Lordship. Now, Lordship will see there are about 7 issues. And I'll not read the issues then, because it is mentioned in the judgment. Each issue has been listed. Paragraph 5, page 202. Last 4 lines. Paragraph 5. JD number 1. File evidence of 2 witnesses, namely Virendra Kumar Patra as JD number 1 witness and T. Shankolal as JD number witness number 2. The JD witness number 1 did not turn up for confirmation due to health reason, and finally, this evidence was expunged. The JD witness number 2, T. Shankolal submitted evidence in shape 2 affidavits supporting the contention of petition and exhibited the following documents. So here only, Lordship, we have exhibited. Instead of they exhibiting the document, we have exhibited this document. Lordship will see that exhibit JD number 3 is a copy of declaration. Exhibit JD number 4 is a copy of agreement. All these documents we have exhibited. It was their burden to exhibit those documents. And which documents were obtained by us from the case record later on, when the decree was sought to be executed against the petitioner, Lordship. Now, next page 204, paragraph 7. During cross-examination, JD number witness number 2 stated that he is corporate advisor of petition number 1 only, and he is not connected with JD number 2. PD number 2 said that one Harish R. Patel, his friend, and he was director of JD number 1, appointed in the year 1994, and he continued as director up to 2016. Mr. Pinaki M. Patel was appointed as a director of JD number 1 on so and he is still continuing as director. PW2 further stated that he knows that Shri Pradeep Kumar Bajaj, were all appointed as directors on 18/1/2010 as directors of Asaram Leasing and Finance Private Ltd company, who was financed the sum of rupees 9.5 crores to clear the liabilities of Ecobank. PW2 said that though he had an agreement between JD number 1 and Asaram Leasing and Finance Ltd and Ecobank regarding the opposite finance, but he has not submitted the said agreement in the court. PW2 further said that he knows that Hasmukh R. Patel retired as director of so and so, and he was appointed as director of so and so. He further stated that Hasmukh R. Patel died on so and so. Hasmukh R. Patel was a shareholder of JD number 1 and held so and so shares of JD number 1 company. PW2 stated that JD number 1 earlier managed two groups, RAP group and was headed by Hasmukh R. Patel, and CAP group was headed by Kanubhai Shumibhai Patel. And there was a dispute between these two groups, and this JD number 1 was allotted to RAP group headed by Hasmukh R. Patel, and there was further dispute between the two groups, which was earlier filed by CLB Kolkata, and thereafter on constitution of NCLT in the year so and so the matter was transferred to NCLT Guwahati, which was disposed of in the year 2019. Mrs. Kailash Hasmukh Patel is the wife of Hasmukh Patel, and she is holding 5,500 shares. PW2 stated that this case was raised in the year 2005, but he has no knowledge, and he came to know about this case from one director, Mr. Horace Patel. Mr. Horace Patel is still shareholder of company and alive, but he did not come to adduce evidence as witness in the suit. The tea garden of the JD number 1 company is run by in favor of Mr. Stunty State Ltd as a LLC since 2008. PW2 further stated that he does not know the names of all directors of Mrs. Stunty Garden except one of the directors, Sri Normaladi Saria, who is his son. PW2 stated that the annual turnover of JD number 1 is about 8 to 10 crores and about 40 to 50 lot kg per annum, and it is according to the season. In the year 2008-2010, the green leaf production of tea is about 54 lot kg. The production of tea leaf was down due to acquisition of land measuring 2,500 acres by Central Government of India for airport purpose in the years. The government had paid rupees 50 crores as compensation, and an amount of rupees 1.4 crore balance amount has been. So I'll not read I'll read the issues. This evidence were there, particular evidence I'll point out later on. I'll not read the whole. Page 207. 207, issue number 1. Whether there is any cause of action for the filing application under suspension. Court held that yes, there is a cause of action. So I am not agreed by that. What I am agreed is that the letter on issue number 2 plus page 208. Paragraph 12. Whether the petition filed under section 47 of CPC is barred by law of limitation. The issue at hand pertains to the essence of the dispute. After a meticulous examination of case record, it is evident that the present petition was lodged under Order 47 of CPC to contest the judgment and decree issued by this court in Manisut number so and so. The petitioner, Duluth Company, identified as defendant number 1 in money execution case number so and so, has contested the judgment and decree of Manisut number so and so, citing fraudulent acquisition and subsequent nullity as ground of silence. So I challenge the decree on the ground of nullity, fraudulent and nullity. Conversely, the appeal disputes the petitioner's claim and contended that the petition under section 47 CPC is legally barred due to law of limitation. Allegedly, in 2006, the petitioner, defendant number 1, filed miscase number so and so, order 37 rule 4, laid with order 9 rule 13 of CPC in an attempt to annul the judgment and decree dated so and so. The rejection of petitioner's plea on 9/3/2007 was deemed final. Subsequently, after considerable time and had lapsed, the petitioner sought to file a current application under section 47 CPC contesting the judgment and decree on the ground of fraud and nullity. It can be raised at any stage. I will place the citation, Lordship. Now, having examined the contention of the involved parties, the court has meticulously reviewed the pertinent legal principle. It is discerned to that the period of limitation for initiating petition under section 47 to challenge the judgment on the ground of nullity is not especially stipulated in the Limitation Act. Nevertheless, the period of limitation for a similar petition under section 47 of CPC falls under the purview of Article 137 of the Limitation Act. which prescribes a 3-year limitation period for filing such application, given the absence of specific period for instituting petition under section 47. In view of this, the court holds that the period of limitation for filing a petition under section 47 of the CPC ought to be governed by Article 137 of the Limitation Act, intending a 3-year limitation period from the date of the judgment and decree. Thus, if this portion of the judgment is not at all correct, I'll come to Article 137 of the Limitation Act. Then next, Lordship will come to paragraph 16. Upon review, it is noted that the petitioner previously filed case number so-and-so, dated so-and-so, with order 9, rule 13 of CPC set aside the judgment and decree in money suit number so-and-so. In paragraph 4 of the petition, JD number 1 specifically stated that the petitioner became aware of the judgment of decree so-and-so when the assistant manager of petitioner JD number 1 visited the Revenue Department office deputy Commercial Customer Silchar regarding a land acquisition matter. The petitioner claim of being unaware of the judgment and decree until so-and-so is contradicted by this earlier statement. The previous petition to set aside the judgment was rejected, and the current application challenging the decree and judgment decree as void and null is considered barred by the 3-year limit. Actually, it was not my case that I came to know about the judgment decree long time back. My case was that when it was sought to be execution, it was relating to execution only. I am not speaking about the order and the decree. It came to my knowledge when it was sought to be executed against the petitioner in the year 2022. That is one part. Now, Lordship will kindly come to Article 137 of the Limitation Act. Whether a period of limitation is 3 years. Limitation Act. First of all, Lordship, when the fraud and nullity is alleged in the execution proceeding, my lord, the issue of limitation will not come. That is my first submission. It has got no bearing. When the fraud is claimed, I'll place some judgment. Fraud and nullity. There is no period of limitation prescribed. And
Mr. Khatani, are you aware of the recent judgment of the Supreme Court, where Supreme Court has directed that within 6 months from the
yeah. That is there.
decree has to be
Not
executed?
only that, well, our Lordship, from here also some Lordship, from here also some instruction has gone to the courts below. That is there, but not in this type of cases, Lordship, because it was stated like a suit, and the matter was decided like a suit. Issues were framed, evidences were taken. This is not like ordinary execution proceeding, Lordship, in my respective submission. This was like a suit. And Lordship, see how the judgment was delivered. Each and every issue I'll meet, Lordship. If Lordship finds that yes, it is yes, the executing court is correct, then Lordship will decide. I don't mind. And now Lordship will kindly come to 137. It should be disposed of, yes, but in accordance with law. Lordship will decide the law. I don't mind. Because
No, that direction was not for High Court, but for the
yes,
court,
from High Court also.
for the executing court.
The High Court, my lord, Honorable High Court also framed rules
Yes,
and
yes.
issued to the lower court.
That is issue to dispose of, not that my objection.
High Court also issues certain.
Yes, from High Court also it is issue in terms of Supreme Court. But it has to be done in accordance with law. My case has to be decided. Decide. Take the hearing should be done day to day. That I do not mind. Yes. Lordship will come to Article 137. Any
Part of
application-
limitation, yes.
Yes. Because there is no particular provision whereby in case of fraud or nullity, there is no provision for limitation. Section 137, here's reopened, section 137. Any other application for which no period of limitation is provided elsewhere in this division. 3 years. And most important thing is that when from this 3 years will start. Thus we will find for time from which period begins to run. When the right to apply accrues. So my right to apply for under section 47 is accrued only in the year 2022. And the learned executive court wrongly said that no, from the date of judgment and decree. Thus you will find at page 210. He did not apply his mind to the provision. In every case, no, the limitation will start not from a particular, it will start from the date from which right to accrue arises. Each and every case, that you know.
Yes.
Losses will again come to page 210. What the learned executive court has held, first two lines, page 210. Entering a 3-year limitation period from the date of the judgment and decree, whereupon he goes. That is one issue. Then, Lordship, secondly, Lordship, my submission is that in case of, if there is any allegation of fraud and collusion, there is no period of limitation at any point of time, anywhere you can raise that point. That there are some, I'll refer to that. First, I'll refer to, I have copies, I'll deliver to 1993 to SCT. Hold on, here more. Lordship, this Chiranjit Lal, Srilal Goenka versus Jamshid Singh, 1983 to SCC 507, paragraph 6. Lordship. No, sorry, paragraph 18. Paragraph 18.
Yes.
It is settled law that a decree passed by a court without jurisdiction on the subject matter or on the ground on which the decree made, which goes to the root of the jurisdiction or lacks inherent jurisdiction, is a quorum non-nullity. A decree passed by such court is a nullity and is non-est. Its validity can be set up whenever it is sought to be enforced or is acted upon as a foundation for a right, even at the reserved stage of execution or in collateral proceeding. No matter when it is sought to be enforced against a particular person, then he has got the right to challenge it. So, if at all Limitation Act applies, then the limitation will start from the date of accrual of cause of action, accrual of right. Paragraph 18. Yes. CC online. 16 FCC online, Delhi 6516. Here, my lord, Supreme Court judgment was referred.
Paragraph number?
Paragraph 10. Supreme Court judgment that is in Prem Singh was relied upon in that case.
Yes.
Paragraph 10. On behalf of the reputation of defendants in the reputation, reliance is placed upon the judgment of the Supreme Court in case of Prem Singh. That judgment I will place later versus Birbal. But it is seen that this very judgment holds the issue of limitation qua challenge to a document falls under two categories, a voidable document and a void document. When the document is obtained by coercion, fraud, or undue influence, then the document is voidable and will have to be challenged within the period of limitation as per Article 57. But if the document is void document, then the fact there is no issue of limitation for filing the suit to challenge the void document. So there are two issues. One is voidable, one is void. If document is void, when a document or decree is void, then there is no issue of limitation. In void means that it is non-est from the very inception. That is also knows. That is settled position of law. So since it is void, so where is the question of challenging it? Automatically it does not exist. It's a decree passed on. Those documents is a nullity. So it can be raised any any positive. That this judgment was relied upon from judgment of the Supreme Court, Prem Singh and others. That I'll place it. Lawsuit will go through it. I'll not read because Prem Singh. No, 65 SCC 353. Yeah, 1961 Assam. There is another judgment from our High Court. I'll just refer to it. I'll place it later.
Come to other points.
Yes. This is the judgment. Paragraph 1961. Paragraph 7. No. No. Realize it. Paragraph 7. No? Yes. I'll not read paragraph 7. 1961 AI 1961 Assam 14. Page 14.
But Mr. Khatuniar, you have submitted that you came to know about the judgment in the year 2022.
Yes.
But the executing court in the paragraph number 16 held that you came to know about the judgment and decree on 23rd 5/2006.
That is the perversity lawsuit. My right accrued only after it was sought to be executed. That difference lawsuit will kindly see. Knowing about the decree.
That is not the verbal statement. That is the statement made by you in the paragraph number 4 of the petition.
Paragraph number 4. No. In the petition, I have stated that we have come to know about our objection lawsuit. No, lawsuit is referring to our objection. Our objection. 47%.
Page number?
No. 42.
So, you have filed on miss case, being miss case number 52 of 2006 under order 37 rule 4 with order 9 rule 13 of the CPC.
That is another aspect also. That is an application for setting aside the
That's all right, but there you have made a categorical statement
no,
that
that
you
is
came
about the decree lawsuit.
Hmm?
So there is two parts lawsuit. After the passing of the decree, as already I mentioned, they tried to execute the decree against not against me, against the judgment letter number 2. It was not executed against me for all these years. Suddenly, they sought to execute the decree against me in the year 2022. That is the difference, madam. That was not considered at all. That is my grievance. Had it been considered, you give a finding on that, I agree. But if it is not considered, then what will happen? And that was also challenged by us, that that application was not filed by, not filed by a person duly authorized by the company. Anyway, resuming. So that was an application for setting aside the decree. About the decree, we came to know, but we did not know about this fraudulent action of the respondent. We came to know when we obtained the documents. Because these documents were not exhibited in the suit. Neither is referred in the order lawsuit seen. Only one document is referred, that is deed of agreement.
Okay.
That is also not exhibited. Without considering that document, those two documents, how the decree could be passed? Because they have concealed those two documents from the honorable court. And this has happened because of the misrepresentation of fact. Entire facts were misrepresented. All false statements were made in the suit, and that was not considered because they did not place the documents before the honorable court. Had it been placed, the court could have come to a different finding. And we came to know about these two documents, lawsuit, only in the year 2022. That is my specific submission, lawsuit. There is a difference between the two. Because we will agree when it is sought to be executed against the petitioner. Not prior to that. Prior to that, we could not have filed any application. Only we prayed for setting aside the decree. For setting aside the expert decree. That was for a limited purpose. So again, next issue lawsuit will kindly come. 210. Next issue.
Yes.
210. Next, no, 308. Issue number, paragraph number 12. Oh, sorry, that I have read. Yes, 210. Paragraph 18 lawsuit. Issue number 3. Whether the petition filed under section 47 CPC is maintainable in view of dismissal of application filed in the year 2006 by the petitioner. Again, that application was referred. Because of the fact that I filed an application under order 9, rule 13 and under order 37, it is held that is barred by this subsequent application for execution, objection is barred. The section 11 of the CPC. Now, lawsuit will kindly read. In the present case, it is established that the petitioner number is JG number 1 of the ongoing execution application. Previously, petitioner filed this case number 5206 under order 37 rule 4 read with order 9 rule 13 of the CPC to set aside the judgment and decree on the basis of that the summons were not duly served. So there is clearly clear finding that someone was on the basis of that the summons were not duly served. Order 13 application was filed. This issue was not there at all. It could not have been because this issue was raised only after 2022. After it was discovered that the judgment or the order was passed without considering these two documents which were void. And on the basis of those documents, the decree order could not have been passed. The court, however, rejected the request and the resultant rejection order attained finality by remaining unchallenged in a higher forum. In the year 2022, the petitioner subsequently filed current application in so attempting to challenge the judgment and decree on the ground of nullity and voidness. So this is the issue now in the execution proceeding on the ground of nullity and voidness. The primary point of contention pertains to permissibility of the petition filed under section 47. Considering the rejection of earlier application under Order 37 Rule 4 of CPC. In this context, the court finds that in the event of rejection of petition under Order 37 Rule 4, read with Order 9 Rule 13 of CPC, aiming to set aside and expedite judgment and decree, a subsequent petition under Section 47 of CPC challenging the same judgment on the ground of nullity and voidness may not be maintainable. So on these grounds, earlier applications are not filed. Earlier application, even the order says that it was filed on the ground of non-service of notice. That was a different issue. That till that time we did not appear in the case. We were not allowed to file our defense at that time. So that was on a different issue. Assuming that I filed an application, that was on a different issue. On the ground of non-service of notice. Section 47 of CPC outlines that to set aside a decree based on the ground of nullity, it is imperative to establish that decree was void from its inception. The rejection of a petition under so-and-so by the court implies a determination that decree is null and void.
It is not.
Is not sorry, is not null and void. So the Nadad court assumed that by merely filing an application under Order 9 Rule 13, now you are barred. Because it implies that determination that the decree is not null and void. That was not the issue in that application. Again, I am repeating lordship. How determination in that application will imply that
Okay, you come to next point.
Yes. Nevertheless, should new grounds and circumstances arise, we should not previously consider the court may. Yes. Now the new ground has arisen in this case. Upon reviewing the case in hand, it is evident that previous application filed under so-and-so by petitioner Duluthi State was based on the ground of the impending order itself says, based on the ground of non-service of notice. No other issue. Currently, by the same petitioner, a decree was issued in 2003 for the recovery of 40 lakhs owned by Hasmukh R. Patel. So the 40 lakhs owned by Hasmukh R. Patel to the decree holder. The petitioner argues that though the money was owned by Hasmukh R. Patel in the name of petitioner, petitioner number 1 was not a party to the agreement, already I have submitted, which was instead signed by Ambalal Properties and Investment, JD number 2. Consequently, the petitioner alleges being made a party to the loan by Hasmukh R. Patel in a manner characterized malicious and collusive with the decree holder. Given that no representative from JD number 1 endorsed the agreement with Hopina decree holder. Notably, the petitioner appealed for setting aside the ex parte judgment and decree passed in Manishut number so-and-so under order so-and-so, contending that the decree was secured in collision. The order itself is contradictory. Earlier, he said that it was only on the ground of non-service notice. Now, he is saying that contending that decree was secured in collision. Importantly, it is apparent that the petitioner was capable of presenting the facts of non-signing the agreement and the collision with JD number 2 in the preceding application. How? That collision was discovered later on, not earlier. The petitioner's failure to raise aforementioned grounds in the earlier application filed under Order 9 Rule 13 of the CPC, followed by their subsequent inclusion in the presentation under Section 47 of CPC, may result in the application of constructive res judicata. It is well established that legal jurisprudence that if the petitioner could have introduced a new ground in the earlier petition application pursuant to Order 37 Rule 4 and Order 9 Rule 13, but neglected to do so, the doctrine of constructive res judicata is applicable. The doctrine precludes a party from introducing new pleas that could have been presented in a prior proceeding. Consequently, the court may determine that newly raised grounds in Section 47 division under Order CPC, under the CPC are subject to constructive res judicata as they could have been raised in the previous petition filed under Order 47 Rule 4 in conjunction with Order 9. So I have already explained, Lordship, that issue was different and now this issue is different. This issue was discovered only after obtaining the documents on the basis of which the decree was passed. Upon careful consideration of the pertinent factors, the court is observed that the newly raised argument by the petitioner appears to constitute constructive as due to the following reasons. The grounds presented in the current application could have been brought up in the petitioner's earlier petition. Could have been. Now he is saying that could have been brought up. The petitioner deliberately withheld these grounds. No question of withholding. The new grounds appear to seek rehearing the same issue. In the light of after discussion, the court assesses that petition filed to ensure does not appear to be maintainable. So Lordship has seen how the order is passed. Once he says that the issue was different, now he is saying that that could have been raised. He did not responded to our submission. We said that this issue has been discovered now after authority documents. Now, next Lordship. These are the three main issues in the light of the issue number 4, 5, and 6. Three issues were decided in paragraph 25. Issue number 4 relates to the fact that as to whether the judgment and decree passed in summary suit number so is null and void. Issue number 5, whether the judgment and decree passed in summary suit number 196 was obtained by playing fraud. Issue number 6, whether the judgment and decree passed in summary suit number so by the court without jurisdiction. So these are the three issues, Lordship. The three opposite issues are interrelated and are therefore being collectively deliberated upon and resolved. Issue number 4 concerns the nullity and voidness of the judgment and decree entered into. Issue number 5 pertains to the petitioner contention of fraudulence in obtaining the judgment and decree. Issue number 6 resolves around the question of whether the judgment and decree pronounced in summary suit number was carried out without proper jurisdiction. The petitioner submission, it was asserted that judgment and decree was rendered against the petitioner and Hasmukh R. Patel based on agreement dated 24/9/2003. 2003, to which the petitioner was not a party and did not affix a signature. That was one issue. Additionally, it was alleged that the petitioner was implicated in the loan acquired by ZD number 2 in connivance with decree holder. Furthermore, it is contended that the judgment and decree are untenable given the decree holder's status as a property firm. As per established legal precedent, which excludes judgments and decrees against property firm. The submission also stated that late Harshit R. Patel, in coalition with decree holder and Hasmukh R. Patel, purportedly signed the agreement using the name of a non-existent entity. Moreover, it was argued that the loan was obtained without proper authorization and execution, thereby deeming the petition non-maintainable and barred by Assam Money Lending Act. So these are the issues which were raised. One of the issue that the suit was barred by Assam Money Lending Act. That was not discussed, not decided. And there's another issue that as regards the documents, those are not at all considered. Now, the burden of proof lies with the petitioner to establish the plea of voidness and nullity. The necessity of the substantial elements such as lack of jurisdiction, court incompetence, and violation of national justice, principle of voidness. Meanwhile, nullity can be sustained through evidence of fraud, collusion, improper service, want of jurisdiction, proceeding, irregularities, and statutory violations. It is apparent from the documents itself. Those documents are not considered by the trial court. In support of these claims, pertinent documents illustrating judicial issues or improper service, witness testimonies, unavailing fraud or collusion, proceeding records, unavailing irregularities, and if necessary, expert testimonies may serve as evidence. It is essential to meet the high standard of proof necessitating clear and convincing evidence that suppresses the typical preponderance of evidence standard. This is a general statement made, vague statement and only sweeping observation without considering the documents. Regarding the plea of fraud, the burden establishing that the judgment and decree were obtained to fraudulent means rests with the petitioner. This requires proving that a false representation or material fact was presented with the knowledge of its falsity and intent to deceive. That already I have placed before your lordship, and that it is significantly influenced the court's decision. Various forms of evidence, such as documents, witness testimonies, circumstantial evidence, potentially expert testimonies, are typically employed to substantiate claim of fraud. Notably, the burden of proof rests upon the party alleging fraud to provide clear and convincing evidence. With regard to the lack of jurisdiction, the petitioner must demonstrate the lack of territorial pecuniary subject matter jurisdiction and jurisdiction over the person. It is crucial to highlight any inherent lack of jurisdiction, such as procedural defects. While observing like this, lordship, he ought to have considered the documents which were exhibited in this particular case. None of the documents are exhibited. The recitals of the documents are not mentioned here. How it was, the fraud was committed and it was obtained in collision. Nothing has been discussed and examined, lordship, those documents. To effectively substantiate these claims, the petitioner may need to present various pieces of evidence. Evidence is already there. Exhibits, including documentation demonstrating judicial boundaries, proofs of the cause of action or defendant's location, financial figures involved in dispute, relevant legal status, and records of any procedural irregularities, clear and convincing evidence necessary to fortify the plea. In conclusion, the issues concerning voidness, nullity, fraud, and lack of jurisdiction are interrelated and should be addressed and resolved. These are only repetition and resolved collectively to facilitate the appropriate resolution of the matter at hand. The learned representative of the petitioner asserted that the purported agreement has been fraudulently executed through representation of fact. Specifically, it was alleged that the manager of a non-execution company, Ashok R. Patel, was falsely represented. It was emphasized that the second defendant, referred as judgment number 2, was described as a registered partnership firm in the complaint, and no company existed under the name of Malal Properties Investment. The learned counsel contended that such false representation and concealment of material was considered fraud committed on the court, rendering the decree null and void. In support of his position, reference was made to the following judgments are referred. Conversely, the counsel for the opposing party vehemently argued that JD number 2 representing JD number 1 had entered into the agreement and executed the deed of declaration on so and so, acknowledging the loan amount of issuing check totaling rupees 42 lakhs. Pausing here for a moment, now they are saying that loan to the extent of 42 lakhs was given. In the order itself, also will find. I'll not go back to the order. In the order itself, it is mentioned as 42 lakhs. Wherein the documents, exhibit 3 and 4, it is mentioned as 40 lakhs. Wherefrom they come to finding that 42 lakhs loan was given.
To say that check were issued of 42, not loan for 42.
No. I'll come to that.
it is
Now,
very clear.
here also it's
Checks
mentioned.
of 42 lakhs.
Loan of 42 lakhs was never obtained. According to them, admittedly, 40 lakhs. That is there. From the, if had the documents been examined, the court would have come to the finding that yes, only 40 lakhs loan was obtained, rightly, wrongly. But it is mentioned as 42 lakhs. It was further asserted that.
I'm sorry, sir, you read it correctly.
Why are you?
No,
I'm coming to that.
You are, why you
I'm coming.
No, you read.
No, it is
correctly.
mentioned, it is in order.
No, at least you read correctly. Where is that?
Acknowledgement
Loan of 42 lakh was there.
issuing says totally 42 lakhs, it is mentioned in the order. If required, I'll come to that order. May I
Not
come?
necessary, you
Yes.
carry on.
There is a mention in the order itself. I'm not going by this one. The court, after carefully reviewing the evidence presented by the petitioner, found that the evidence, which evidence? Nowhere mentioned. Who the exhibit, the one witness was examined, his evidence is never nowhere mentioned. In miscellaneous case number so belonging to the petitioner, admitted that Ashok R. Patel was the director of the petitioner during the event period. Now, pausing here for a moment. Now, the whole order also will find that he has assumed, the learned executing court assumed that supposing he was mentioned as managing director in the documents. Now, here finding is that he was a director. Now, assuming that whether he is director or managing director, he alone does not have any power to receive loan. That is admitted fact that there must be a resolution of the company. I'll come to that provision of the law. The witness also acknowledged that Patel was responsible for receiving a loan amount on behalf of the petitioner by executing certain documents. The court also noted that the petitioner failed to provide evidence to support the claim of non-existence of Ambalal property and investment. The petitioner's argument that Hasmukh R. Patel was solely responsible for refunding the loan amount as the decree was non-executable against JT number 1. This was based on the testimonial petitioner's witness PW2, who stated that Patel was the director of the petitioner at the relevant time, and therefore the responsibility for refund could not be solely attributed to Patel. So merely because of the assuming for a moment that he was a director, but their case is that he was managing director, whether he has got the power. The petitioner's counsel contended that an agreement for illegal consideration cannot be enforced, and the money paid under it cannot be recovered. Reference was made to Section 70 of the Assam Management Act 1934 and a judgment of the parent High Court. However, upon careful examination, the court found no substantial evidence to support the claim of illegal consideration in the agreement. Upon careful examination of what? Not mentioned. Furthermore, the petitioner argued that 2005 judgment and decree was lacking jurisdiction, citing 11 case law. Following a thorough review of the case record, the court determined that the judgment was indeed within the court's jurisdiction, thereby dismissing the petitioner's argument. Subsequently, petitioner contended that suit filed in the name of a sole proprietorship firm was not maintainable and that a relevant party was not included in the case. Upon scrutinizing the case record, the court ascertained that the suit was properly filed and that the loan was legally recoverable. Under the opposite circumstances, the agreements presented by the petitioner counsel do not appear to be justifiable. Upon careful examination of records, the court has determined that Exhibit 3 is a copy of declaration that is 24 is a copy of agreement that is 22, and Exhibit 2, 5, and 6 records related to MS 22. The substance of Exhibit 2, 3, and 4 reveals that Hasmukh R. Patel as the managing director. Now he is saying that in the Exhibit 3 and 4, he is described as managing director. Contradictory finding. Acquired a loan of 40 lakhs from OP number so-and-so and issued 5-6. Furthermore, Exhibit 4 demonstrated that an agreement was signed between Hasmukh R. Patel representing Ambalal property and investment with DP holder at the time of mortgaging the property of Ambalal properties in favor of DP holder OP. The oral evidence presented by PW2 confirms that Hasmukh R. Patel was the director. Now he is saying that he is the director of JD number 1, appointed in 1994, serving until the year 2009. It is noted that Hasmukh R. Patel retired as director on so-and-so and appointed as director of JD number 1 on so-and-so. Additionally, PW2 acknowledged that Hasmukh R. Patel was a shareholder of JD number 2. Now he is saying that he is a shareholder. JD number 1 holding 5,765 shares of JD number 1. The involvement of two groups, RFP group headed by Hasmukh R. Patel and CAP group headed by Kanubhai Shumibhai Patel in the management of JD number 1, along with subsequent disputes addressed through legal avenues, was elaborated upon operational details of JD number 1 were provided with insights into its tea garden and associated agreements. Furthermore, the legal and ownership structure of JD number 1 and 2 were clarified, including the respective shareholding of Patel Company. The statement pertaining to the criminal case filed by JD and its director and partner was acknowledged, despite limited awareness about the specific details surrounding it. Overall, the evidence examined shed light on the intricate legal, operational, and ownership aspects of the entities involved, providing valuable context for the proceedings. Subsequent to the examination, it was established that the exhibit documents so-and-so were drafted between so-and-so. At that time, Hasmukh R. Patel held the position of director. If he was a director at that time, then why he was ascribed as managing director? So in the name of managing director, he obtained the loan in the name of the petitioner company. In this context, it was ascertained that Hasmukh R. Patel possessed the necessary capacity. Just because of the fact that he was the director, so he possessed the necessary capacity. The court found that no grounds to question the authenticity of Exhibit 3 document, which explicitly stated that the loan of rupees 40 lakhs was acquired by Hasmukh R. Patel, who held the position of director at Duluthi and was identified as JD number 2 in the execution application, while Duluthi company was donated as JD number 1. Upon careful examination of evidence, the court concluded that Duluthi company failed to substantiate the assertion that judgment and decree were secured cohesively with Hasmukh R. Patel by the decree holder. The evidence presented by PW2 clearly indicate that Hasmukh R. Patel possessed the capacity to secure the loan, given his role as director of at the time of execution. Again, he is saying that he was the director at the time of giving the loan. Now, the court has held that subsequently the court determined that petitioners were unable to corroborate the claim that judgment and decree in issue number 4 were invalid, consequently so and against the petitioner. And issue number 7, whether petitioner is entitled to it. Now, lordship, what is the law regarding obtaining loan by a company? Who is authorized? That is a very, very vital issue. If he was not authorized to obtain the loan on behalf of the company, then whole thing goes. It is alta affairs. Thus, we will continue refer to company law. Company law. Company law governed by 1956. Now, 2003 company law is not applicable. 13 not applicable. Earlier act, that is Companies Act 1956 will be applicable. 56.
It is not available with the court.
1956.
Will be same, my lord.
No, anyway, but we have to
Only
particular.
Only few
I
changes
can
are
hand
made.
over. That's it.
2013 and 1990.
It is very specifically mentioned.
Mostly same, my lord.
Without a resolution of the company, no director or managing director can obtain a loan. If that is so, the entire the proceeding is alta-affairs. Section 292 and 293 of the
290?
Companies Act.
290?
292 1 clause 1 C. Clause 1 C is more appropriate. I can read that only that portion. The board of directors 292 1 C. I read slowly, only one provision I read, but the entire the board of directors of a company shall exercise the following powers on behalf of the company, and it shall do so only by means of resolutions passed at the meeting of the board. One says like that, and then C. The power to borrow money otherwise than on debenture, except a resolution, this C cannot be used as authority given, provided that there is a provision, lordship. Proviso. That the board may, by resolution passed at the meeting, delegate to any committee of directors, the managing director, the manager, or any other principal officer of the company, or in the case of branch office of the company, a principal officer of the branch office, the power specified in clauses C, D, and E to the extent specified in section 2.3, subsection 2.3.4 respectively on such condition as the board may prescribe.
Amount to be collected.
Again, lordship will say 292 2. 292 1 clauses are there, provisions are there, then thereafter 292 2 within bracket 2. Every resolution delegating the power referred to in clause C of subsection 1 shall specify the total amount outstanding at any point of time up to which the monies may be borrowed by the delegate. Even the amount should be mentioned in that resolution, that you are authorized to borrow money to that extent. That must be maintained, that placed before the honorable court. That was not there apparently because of the fact that the resolution number itself is missing. So that is, it is admitted that resolution is required. That is what I am submitting, Lordship. They also admit that resolution is required, but not mentioned, not taken resolution. And check number is also not mentioned. Date is not mentioned. Then Lordship will kindly come to 223. 293 1D. Just kindly note, Lordship, I will not read. Same, it is repeated. Or if required, I can hand over my copy.
Not necessary.
293 clause D. And articles of association of the company also. Articles of association, which was exhibited in the case, in the executing, before the executing court. That was not at all referred, these opinions were not at all referred. That was my basic submission before the honorable court. Article 58 of our, of the companies, that is petitioners, articles of association. Article 58. It is a special mention. This is our article of association. This was exhibited on 58 also. Borrowing power. The board may, from time to time, at its discretion, subject to the provision of section 292 and 293 of the Act, raise or borrow either from the director or from elsewhere and secure the payment of any sum or sums of money for the purpose of the company. Raise or borrow money. That was exhibit 7 in the before the executive court. Exhibit 7. This was also not considered. Now, in this regard, I will place one judgment, Lordship. Constitution-based judgment of the Honorable Supreme Court. Paragraph reported in AR 1963.
AIR
1963. SC 1185. This is constitutional bench judgment. Paragraph 16 and 17. Last. Where a company does an act which is ultra-virus, no legal relationship or effect ensures therefrom such an act is absolutely void and cannot be rectified, even if all the shareholders agree. In so and so, the payment was made pursuant to the resolution was therefore authorized, and the trustees acquired no right to the amount paid by the director. In that particular case, Lordship, the resolution was there, but it was not appropriate. It was illegal. Even then, court held in paragraph 17. The only question which remains to be considered is whether the appellants were personally liable to refund the amount paid to them. Appellants 2 and 4 were at the material time directors of the company, and they took part in the meeting held under the chairmanship of the fourth appellant, in which the resolution which we have held ultravirus was passed. As officials of the company responsible for passing the resolution ultravirus, the company they will be personally liable to make good the amount belonging to the company, which was unlawfully disbursed in pursuance to the resolution. So in that particular case, it was held that the directors who had illegally passed the resolution, they are personally liable to repay the amount. Here also, Lordship, our case is that if Harshad R. Patel, he has received the money in the name of one diluting company without having any authority of law, then let him personally pay. We do not have any resistance. From initial stage, we have been saying that we are not against the execution, against the defendant number 2, Harshad. And in fact, they proceeded against him. And without any taking any steps as per the order passed by the court, then they jumped upon me and tried to enforce the decree against me. Actually, the decree was passed against one defendant. Defendant is referred to as defendant, and the defendant agreement was between that defendant, not me.
Rest of the defendant.
No, so I already passed the order. It is not specifically mentioned who is defendant. Defendant and the agreement. If it is seen, both the things related together, then it will find that the agreement was between Ambalal.
No, how many defendants were right in the plane?
Plane two defendants.
Two.
I was the defendant number 1, petitioner. And they were the defendant number, they were plaintiff. Defendant number 2 was Ambalal, for short. And he invented everybody. The Ambalal company, Ambalal partnership, he invented everybody because there was no existing company.
All right.
That is the fraud.
What is your next point?
Yes. And now, some more.
Defendant given in the agreement.
Yes.
Defendant in the
Agreement. Defendant in the agreement.
Page 64.
I'm not referring, the lawsuit will kindly peruse the
Page 60.
page 64, Exhibit X, 5, sorry. Page 5, Exhibit 64.
Page
64 of the
Yes,
petition.
petition.
Address of the defendant given. So our address was not in the agreement. Address of the defendant given in the agreement.
It is a suit for summary trial, therefore summary summons sent by post in the address of the defendant given in the agreement. So agreement, defendant, which defendant? Defendant, they are the party only, not the Dulu. Dulu was not a party. So there is no address of petitioner in the agreement. Also, can you see how the matter was dealt with? No, just a minute.
Typing mistake.
Every time every time is they are referred to agreement. Actually, the decree was passed against Ambala.
Okay.
And
Do you have any other point?
Yes, I have some judgment. Yes, other points are there. Namely, that the partnership firm, cooperative firm was made a party. The plaintiff was a cooperative firm. But the the cooperative firm cannot file a suit. That law is there, I'll place in its name. And there are so many. Cooperative, there are so many judgments, I'll place, I'll not read.
Not necessary.
Yes.
Okay.
Cooperative firm,
What is the citation in connection with this point of law?
this point.
Yes.
Yeah. I'll give the judgment.
No, that's all right. You first give me citation.
First of all, Lordship will see our High Court judgment in RFA number 7 of 2009.
IFN number 7
of 2009.
Division bench, para 46.
This is a division judgment, division bench judgment, para
46.
para 46.
Yes, next.
Then I'll give the, actually, I'm submitting one written argument, where everything is mentioned there. Just I merely add so many references. It will
No,
require
no,
some.
so many
Yes.
references not
No, I
required.
have already given.
And any other point,
Yes, another point is that the suit was barred by section 7D of the Assam Money Lenders Act. That point was not at all discussed.
section 7
D.
D.
Of the.
But whether you have raised this issue before the.
Yes,
executive court?
it is referred in the judgment. It is referred, but not
Section 7D
of the Assam Money Lenders Act. It is referred in the judgment, but not decided. That is my grievance, Lordship. You decide in accordance to law, maybe in my favor or against me, but you decide. Assam Money Lenders Act, 1934. Lordship, can you go to section 7D? What? No, but I don't go there. Seven D, Lordship.
But whether the suit was filed under this act?
My lord?
Whether the
No,
suit
no,
was filed under this act?
what I am trying to say, Lordship, because it is a case of money lending. If someone lends the money, if any suit is sought to be filed in the court, then without a certificate, the suit cannot be filed. There is a bar. That is why we are saying that the lack of jurisdiction in the court.
Okay.
Because of the,
What are the other points?
Lordship, because of section 7D of Money Lenders Act, the suit is barred. I'll just read, I'll not take much time. No suit for the recovery of loan advanced by a money lender shall proceed in a civil suit until the court is satisfied that he holds a valid registration certificate or that he is not required to have a registration certificate by reason of the fact that he does not carry on the business of money lending. So first, before proceeding with the suit, he will have to satisfy the court. Unless he satisfies, there is a bar. So the decree or order or the decree could not have been passed without following this provision of law. That is my submission. Therefore, the decree was passed without jurisdiction. But the learned executive court did not decide on this point. Did not touch, although he has referred to section 72, cooperative farm, everything is decided.
Whether in a petition under section 47 of the CPC, the court can decide all these issues?
Yes, if the suit, if the decree was passed without jurisdiction, then it is a nullity. I'll place order judgment. If it is a nullity, it can be raised at the execution proceeding. Possible, better to place the judgments on this point. Without jurisdiction. He did not apply his mind. He made some general observation without referring to any particular provision, without referring to the laws placed by us. Made some general observation. And Lordship, apart from that, actually, all this regarding the nullity, fraudulent action, collision, all these facts were mentioned in our objection and in the evidence, witness. We examined one witness. Our witness very clearly said that yes, this is the things. That is how the documents are, the decree was fraudulently obtained, and these issues were not contested by them. No cross-examination on that point. So on that point, I'll place one judgment. If there is no cross-examination, no denial, then it will be deemed to have been admitted. 2016.
Whether you have filed an objection there?
Yes, my lord, I filed.
Yeah, fine.
I cross examine let my learned
I am not pressing if I am given time. my lord,
Mostly, my lord, my brother is taking here and there, not to the point.
if I am given time, my lord, I can go through entire evidence. Entire evidence you will also go through.
Factual.
Better than
my lord,
I should.
facts should be, my lord, brought to the notice of the honorable court correctly, my lord. That's my.
And that is why I wanted to go.
No, you briefly state the other points because
Yes.
you have
that is one
already
point.
taken more than 1 hour.
I'll
Nasib,
take only 5 minutes, my lord.
he will take 5 minutes. He will only say that they are trying to delay.
No, to the only.
That is not the.
Facts I'll take only 5 minutes.
That is not the solution. Nasib.
Facts are there. On paper.
2016 असलं ना. Now, on the point of nullity and fraudulent, I'll place some judgment that it can be raised at the time of execution. Now, AR 1954 SC, you have to solve. Page 340. Kiran Singh versus Kiran Singh and others versus Shaban Paswan.
Kiran Singh
Paragraph
versus
6.
Kiran Singh
Kiran Singh versus Shaman
the money that at that time also, my lord. When the money was attached, my lord, then this petition was filed, my lord. Miss case 52 of 2006, my lord.
Page number?
Page number 236 is evidence, my lord. 236 of my evidence.
30?
236, my lord.
It's 6.
My lord. This is the evidence on affidavit, my lord, filed by the petitioner in support of his petition under, my lord, Order 9, Rule 13 and Order 37, Rule 4, my lord.
Order 9,
Rule 13 and Order 37, Rule 4, my lord. It was a joint petition, my lord. And my lord, the allegation that they did not receive the summons, my lord. I'm just taking your lordship to, my lord, page 242, cross examination.
No, not necessary to go into that.
My lord, he admitted AD card was there, my lord. AD card was there for service, AD card of service of notice on the petition, my lord. It was there, my lord. And it was exhibited during the cross examination of the, my lord, their witness in the miss case, my lord. Secondly, my lord, the fact that in the judgment, my lord, the only in place of defendants, it is only mentioned the defendant. That does not mean, my lord, that it is not against the both the parties, my lord, both the defendants, my lord. It is only a typing, maybe a typing or mistake, my lord. Dependent means include both the defendants, my lord. Suit was decreed against both the defendants. And now, my lord, regarding, my lord, whether they can raise such a point, I'm just the issues, my lord, whether the suit can be filed by the present suit is hit by as a proprietorship. I'm relying on a judgment of this honorable court, my lord. It is reported in 2007 to GLR page 351, my lord. Regarding it is a division bench judgment of this honorable court, my lord. And regarding, my lord, the money lenders act, my lord. In Money Lenders Act, my lord, the section 7D, my lord, barred the suit unless the lender is a, my lord, registered as a Assam Money Lender Act, my lord. So this provision is applicable, my lord, if the person who lends the money is doing a money lending business, my lord, not individual loans, my lord. This is a judgment reported by in 1992 GLJ, my lord, to page 236. 1990 to GLJ, my lord. Page 236. My lord.
30?
236, my lord.
236.
My lord.
Okay.
My lord, here it is the burden lies on the, my lord, the person who alleges that the other party is, my lord, doing money lending business. So he has not discharged that burden, my lord. Now regarding, my lord, the res judicata. Since, my lord, his first application was rejected by order dated 9/3/2007, my lord. So he is precluded from filing this second application, my lord. So on these three, basically, my lord, res judicata, money lending, and, my lord, this proprietorship firm. I'm just relying on three judgments I'm giving, my lord. And regarding, my lord, that he has no knowledge, my lord, I'm just taking lordship to page 249 of my affidavit, my lord. 249. 249 of my affidavit, my lord.
249.
My lord. It was an my affidavit.
Yes.
My lord. My lord, this application, my lord, when I failed to realize my money, my lord, in spite of the attachment of the earlier compensation amount, my lord, then I filed the application in the 2007, my lord, under order 21, rule 37, 38, my lord, for, my lord, civil imprisonment, my lord. Now, my lord, page 250 of my this application, my lord, I have stated the name of all the officers, directors and officers, my lord. It includes, my lord, Ansuk R. Patel, Managing Director, Kanubhai C. Patel, Harish R. Patel, Pinaki M. Patel. Malad, this Pinaki M. Patel is still one of the director of this company, Malad. So, Malad, they cannot say, Malad, that they were not aware of the proceeding, Malad. Now, Malad, Lordship may have a look at page 252, Malad. 252 is the order passed by the Honorable Learned Trial Court, Malad, on my this petition. May I read, Malad, it is only 2-3 lines, Lord. DH is represented by Learned Counsel who files petition number such and such under order 21, rule 46, 46A such and such be kept with record. 3 directors of JD number 1 company made appearance to their Learned Counsel and pressed for time to file challenge the petition number 128, this earlier petition, 242. So, Lord, they have appeared before, they have been appearing before the Learned Executing Court, my lord. And how, my lord, they can say that in the year 2022 they came to know about this, my lord. So their entire case is, my lord, based on falsehood, my lord. Now, my lord, I've just refer one judgment of Honorable Supreme Court, my lord, reported in 1994 1 SCC, my lord. In 1994 1 SCC, my lord. SP Singla Swami versus, my lord.
Page number?
Page number 1, my lord. Page number is also 1, my lord. In their judgment, my lord, Honorable Supreme Court, my lord, if a party tries to obtain, my lord, a favorable order by falsifying, my lord, documents or false something, then, my lord, that party should be ousted from the proceeding, my lord. No relief can be granted to such party, my lord. My lord, entire case of the, my lord, this present petition based on falsehood, my lord. He is denying, my lord, he is denying his own document, my lord, that he has not executed, that he is not a party to the agreement. The agreement was, my lord, signed as a guarantor, my lord. Whereas he himself has, my lord, as by executing a declaration, he has admitted the amount of loan, my lord. He has issued post-dated checks, my lord. How he can deny, my lord? Now, my lord, regarding, my lord, the provisions of Companies Act, my lord, as my friend has submitted, my lord, the provisions of Companies Act are, my lord, applicable for management of the company, my lord. They are not related to, my lord, the third party, my lord. The third party transaction between the, my lord, the company and the third party, my lord, they are not governed by the, my lord, the provisions of Companies Act, my lord. Provisions of Companies Act are, my lord, just to, my lord, to see that whether a company is managed properly or not, my lord, and whether it complies the, my lord, the formalities of registered companies or not, my lord. Only for those purposes, my lord, these Companies Act provisions of the Act are there, my lord.
Okay.
Little reply. They have said that directors of the company, even then that was done in their individual capacity. Also, I have already shown. The resolution, even for repayment also resolution is required, that they could not place. And Lordship, they have referred to page 254, of the 252, Lordship will see. Honesty Company was the additional, and Duluth Company, they have named Duluth Company and others. Others means all those persons. And in the order itself, it's mentioned that 3 directors. Which are the 3 directors? Harsad R. Patel, he was managing everything outside the resolution of the company. He received the money, he then issued check in his individual capacity. Let it be executed against him. That was my submission. Without a resolution of the company.
And, my lord, this petition, my lord, according to themselves, my lord, this, my lord, this very person, my lord, he died in 2021, my lord. After, why, my lord, they are coming after his death, my lord?
What?
The person against whom the allegation is made, my lord, he died in 2021. Why they did not come, my lord, during his lifetime, my lord?
Definitely he will not come, because he was in collision with them. That was my fraud and collision. Fraud and collision.
Okay.
If your lordship, the court did not consider all the evidences on the court.
So your citations are ready.
Yes, I think it. Okay.
You can file today or
Today, huh? Monday.
Monday.
I'll hand over.
Then we'll keep the matter further. We'll take it up on Tuesday.
Monday.
Tuesday.
Tuesday, I have another matter.
Maybe only for filing those citations. Submitting.
Lordship, one thing is there. on 5th of Monday, the execution case is fixed already. So Lordship, the money is already in deposit with the court. So till then, my lord, the money should not be disbursed.
No, no, that has already been released perhaps.
No, not
No,
released.
my lord, the
Lordship, on
client
that
court was not
last
released.
occasion, Lordship,
Presiding officer was my lord transferred. Now he has joined only 2 days.
now, my lord, he misled the court by stating that both the
It is there, my lord. Where is the question of misleading? It is there. It is
he's
there.
disturbing, my lord. He
Why you are making false submission, Mr. Sir?
No, no.
You are a senior advocate. We should not make
false.
such
He is saying false, but what is the falsity? He is saying that both the persons are staying in the same building. But these are two different entities. These are farms. One is company, one is.
Maybe whatever order has been passed already passed.
No, Lordship, I have filed an application for review on that order because of the fact that commission he made on that last particular day, it was not correct. He said that he statement.
You submit the citation on Tuesday.
Yes, that I'll do, but till the disposal of the
Also heard Mr. Gaur learned
till the
order is something.
till the judgment is delivered, Lordship. Otherwise, there is no meaning keeping it. Judgment till the judgment is delivered. Yes, the money is in deposit, madam. It will be disposed of at the earliest. Money is in deposit in the court, before the court. So they will not suffer anything. I am not signing away. Money is already in the court.
No, 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 we cannot.
Only till then.
No,
till
no,
then.
no.
Otherwise, it's meaningless. Just to kindly consider
You
because
can
on the
verbally
date of,
apprise the court that.
because it has happened because of the fact that he made some false statement. That,
No.
why he was not made party petitioner in the case because of the fact that, and on that day I was ready to argue the case and he was alleging that I was delaying the matter. On that day itself I was ready, even at the instance of my lord staying out the one of the parties. Let's kindly consider.
No.
Because let's kindly see the order, not last one, the review petition.
You copy is not given. Copy is not given to me, my lord.
Anyway,
Copy of the petition is also
it's
not.
up to a court. Because he was not available. Only till then, otherwise I don't know. And the money is in the deposit. I am not running
My lord,
away.
they have also filed a title suit, my lord. That title suit
No, that is
also
on different.
challenging this
that is
my lord
different.
victory. So, my lord, if suppose, my lord, if they
Why
succeed,
argue?
they will get,
Let me submit.
they will get back the
No,
money.
no,
my
that is even. Just to kindly see. Because the judgment letter number 2, he did not approach his court. Because all along our case was that there was a collision. He will not definitely come to court. Therefore, we have to make him a party respondent. Lordship, kindly see at page 35. Mr. Gaur, has you also got it? Mr. Gaur, learned counsel for respondent number 1, submits the respondent number 2. His judgment letter and the respondent number 2 ought to have been added as a respondent number 2. Ought not to. Yes. Why? Because he did not come to court. Because he was in collision with him. Definitely he will not
My
come
lord,
to
they-
court.
my lord, there are this much
and
of
that-
bunch of petitions filed by both the parties, my lord.
Why
This
he is
petition number 2 has also, my
Let
lord.
me
when-
first.
no,
Let me
no,
first.
why you are making false submissions? Mr.
That is
Singh? You are
there.
a senior advocate. Why you are misleading them?
That is.
You
Don't say like
no,
that.
yes.
Because it is.
No, you either you
It
have
is
not
your
gone-
submission.
No, it is you, either you have not gone through the
You-
record.
you have-
There are my lord, number of petitions filed by the ZD 2 also, my lord.
No.
Why he is saying
What-
that he is
See,
in collusion with the
Because of the
Sure.
fact that he did not approach the court. The defendant number 2. Definitely he will not approach because the decree was passed ex parte.
He has
He
approved.
did not appear.
He has
He did
approved.
not appear in the case. And he allowed the suit to be decreed ex parte. And here, why he will come, Lordship? Kindly, Lordship, till the judgment is delivered. Otherwise, no point.
No.
Lordship, kindly pass the.
What is the citations on Tuesday? But Tuesday, there will not, there shall not be any hearing. Only
Monday also you
filing
can place
those
it.
citations.
Monday, huh? Yes. Monday.
Monday.
Letter part. Letter part.
Monday. Okay.